Good morning. Excuse me. I have a few matters on the calendar. I'm just going to run through and call the calendar really quick, and then we'll figure out where we are and who all we have and what we still need to do stuff with. Can everybody hear me?
Yes, ma'am.
Okay,
Yes, ma'am.
good. Okay, first position, Ratliff versus AX Auto.
Good morning, Your Honor. This is Jared Faber for plaintiff Ronaldo Ratliff. I also have Cyclone Covey with me.
And
Okay,
King for AX Auto. My client's Mr. Agad is also, I think, down on the bottom if you're looking at it as squares as I am.
okay. Yeah, I've learned that they sometimes can be in all sorts of different orders, but luckily it looks like most everybody is labeled, so that's helpful. So I am, there's some things we're going to need to work through this morning, but what I haven't seen is a consolidated pretrial order. And this is, I think this was set for a pretrial conference in advance of next week's trial date.
We emailed, Mr. Farber emailed one portion and then we consolidated on October 31st our emails to
Okay, I just haven't seen it yet. And so as soon as Mr. Freehoff locates it, he'll forward it to me. So just making sure I have it before we start chatting.
You do have it.
Thank you. And Headway Capital versus Honan Property Management.
Good morning, Your Honor. David Whitridge for Headway Capital.
Hi, Mr. Whitridge. And I saw that I received your portion of the CPTO. Have we heard anything from Mr. Honan or his
Good morning.
counsel?
Good morning, Your Honor. Jeffrey Coleman for Scott.
Hi,
Honan.
Mr. Coleman.
And Scott Honan is also on the call. Unfortunately, I think his phone is listed. It's not listed at his name. I think he was trying to fix it. He
Is
just
that the
had
person identified as iPhone 9?
it is.
Yes,
That's
Okay.
not his actual name, though. He wasn't born by iPhone 9. But yes,
okay.
Your Honor, two things. One, I have my consolidated order is coming to you, but two,
Yes, sir.
this case will be settled.
Excellent.
So
Okay.
I'm working with plaintiff's counsel.
Okay.
We spoke very, very, very briefly yesterday about it, but this case will be settled.
Mr. Whitridge, are you as optimistic about that, sir?
I'm cautiously optimistic. We have not received any sort of offer or any terms or anything substantive. So I'll await hopefully discussions today to see if we can get that done.
Okay. Well, I encourage those. Just so you know, I'm not sure what date might have been on your actual trial notice, but I will tell you that if the case does need a trial, it will be on the first available date that I would call you and would be the 13th. I think you might have gotten the 12th. But it turns out I have to be at some sort of mandatory drug court judge training that I forgot to put on my calendar. So it would be on that Wednesday instead of that Tuesday, just so you know.
Yes,
Okay.
Okay. And I'm going to keep on rolling. I'll come back to you guys in just a few minutes to see if there's anything else we need to address. Girls Galore versus the City of Atlanta.
Good morning, Your Honor. This is Ken Newby for the petitioner, Girls Galore.
Okay.
Good morning, Your Honor. This is Tracy Hackett for the respondent, City of Atlanta.
Hi, Ms. Hackett. How are you?
I'm fine. How are you, Your Honor?
I'm doing fine. Thank you. So just so we're all clear, just so I'm clear on what we're all here for today, right? I know I saw some crossing email discussion about withdrawals of motions to dismiss, but there is still, as I understand it, an active motion to dismiss that the parties were prepared to have heard today regarding the role of Mayor Dickens in the case. Is that accurate, Ms. Hackett, from your understanding?
That's accurate, Your Honor.
Okay, and is that also accurate from your understanding, Mr. Newby?
Yes, Your Honor, along with my motion for transmission of the record.
Well, I sort of think of all that as one thing because I think the outstanding issue is who is the lower judicatory and who is responsible for the record and for transmitting the record. So we'll work through all that. I just wanted to make sure that was what we were here and focused on this morning. Any idea how long you think that might take?
Your Honor, from the city's vantage point, it should not take too long. I'm thinking maybe 10, 15 minutes to present our basis for our motion.
Okay, thank you,
Yeah,
Mr. Newby.
I'm sorry. I'd say about the same, about 10 to 15 minutes. You were right. We did exchange some emails. If counsel maintains the position she took in her email last night, this may be a very short argument because it seemed like there were some things we could agree upon, but I'll wait and see what happens when we actually speak.
Okay, thank you. Okay, and then last up is the Davis versus Barbara Schmidt matter. And the only thing that was on the calendar for today was the pending motion for attorney's fees. The substance of the case has been fully resolved. Who do I have? Ms. Brown, are you here on behalf of the Davises?
Yes, Your Honor, I'm here, and Gary and Molly Davis are also here. They're labeled Zoom user, I believe, instead of their.
I see them. Thank you. And then is it Crimer? Am I pronouncing that correctly?
That is correct, Your Honor.
Okay. And Mr. Crimer, you're here, and I thought I saw Ms. Schmidt as well. Okay. So I'm gonna ask for a time announcement. I'm a little afraid of the answer I'm going to get because I saw some cross email traffic that Ms. Brown was anticipating a full-blown evidentiary hearing, et cetera. And so I think we need to work through what it is the parties had hoped to accomplish, because it was not my expectation that this would be a full-blown 4-hour evidentiary hearing. But tell me, Mr. Crimer, I think from some of the email communication that I've seen between you and Ms. Brown, I think your position is that you've submitted your affidavits and that the only issue is the reasonableness of your attorney's fees. Is that roughly accurate, Mr. Crimer?
Well, pretty much. The key requirements for a 9-15-14 motion are reasonableness of the fees and the necessity. Those are the two variables. But more importantly to that is that Ms. Brown has not responded to our motion. It's been pending for over a year now. She's never responded to the motion. And case law is very clear on that point. When you don't respond to a motion, you don't get to put up evidence. And so for that reason, we don't see that there's really going to be any evidence. What I foresee, Judge, is that I'll get up for a few minutes, state in my place that my affidavits speak for themselves, and we think they're reasonable and necessary. I don't see any need to go through each invoice item by item. I just state generically that they're all reasonable and necessary. And Ms. Brown's welcome to cross-examine me, or I'll state in my place as the court decides. But that's a 15-minute process, if that.
Okay.
So I would object.
Oh, I'm sorry.
I would object to any evidentiary effort to introduce evidence at all for the reason that I just stated.
Okay. Thank you, Mr. Crimer. Ms. Brown?
Your Honor, we had requested an evidentiary hearing, and I disagree with Mr. Crimer's statement that the law is clear that a 9-15-14 motion requires a response. In fact, there is no default 9-15-14, and there's a right to challenge the elements of the statute as well as the reasonable and necessity of the fees. However, we received the court's instructions through Mr. Freehoff that what would be heard today is argument and Mr. Crimer's fees, and we are prepared to cross-examine him. But in terms of additional evidence, we will be making argument as to the elements of the motion as well as the fees, but we do not anticipate calling any additional witnesses. We also intend to make arguments regarding Mr. Crimer's assertions that the admissions are controlling and his arguments that the admissions require this court to grant the motion. So we'll be taking that up. So I anticipate our portion to be, 30 minutes to an hour, depending on how long the cross takes.
Okay. Fair enough. Mr. Crimer, what are your thoughts? It sounds like you were expecting maybe, a few minutes for your presentation, and then I guess I'll hear argument from you guys about whether any of what Ms. Brown just presented was procedurally appropriate. And assuming that I decide it is, then looks like we're looking at about 30, 45 minutes. That sound about right, Mr. Crimer?
Yes, Your Honor, that sounds pretty accurate. And I will say, just so it's in your mind and you're percolating on this, Ms. Brown brought it up. I also say that we have clear admissions that were never responded, and they pretty much go to the heart of our motion. And I also argue that they can't really argue or controvert by argument or evidence the admissions that were the basis for Your Honor's grant of summary judgment a year ago.
Well,
So again, we'll argue that later, but
yep, we'll get to that in a few minutes, but thank you all. If you'll, I'm going to circle back around and deal with the ones that I think can be addressed relatively efficiently. And then I will be back with you guys in a few minutes to address the substance.
thank you.
Okay, so Mr. Whitridge and Mr. Coleman. So I have this down for a non-jury trial. The offer that I saw was for 1 day. It would be if it is called in and it is not resolved through a settlement, it would likely be called in on November the 13th or sometime that week. Or is there anything else that y'all need to work through with me in terms of just for this morning? I expect that if I don't get an announcement of pretrial, given that it is a non-jury trial, that most of the education I might give you about how I pick a jury or how you could expect to do certain things, we can dispense with all that. I think the one question I have is that if we do try the case, typically if it's a trial or a significantly evidentiarily heavy case hearing, I will typically do them in person, even if it's, a bench trial with, minimal evidence. And so the only real question I have for you guys is if we do need to go forward with the trial, do you feel like you need, do you want to do it in person or do you feel like Zoom would be acceptable? What are your preferences, Mr. Whitridge?
Your Honor, I think I put in the order 1 day, but from our standpoint, I mean, this is a fairly straightforward case. It's just a loan that was defaulted on. There's no significant issues except the payment breach and the payment history. There's already been a default order entered on
As to the corporate entity.
company. I put 1 day, but I really think that our portion of the case would be maybe half an hour.
Okay.
So I looking at the answer, I'm not sure if there's any substantive, heavily factual defenses. So from our standpoint, maybe 30 minutes, and I wouldn't mind it. Obviously we could come down if we needed to, but a Zoom or a virtual hearing would be fine also.
Okay, Mr. Newby, what are your thoughts?
Mr. Coleman, you mean? I apologize.
I'm sorry, Mr. Coleman, I apologize.
Understand. No problem. I would think an hour or so, and Zoom would be fine. I don't think this would take up a significant amount of court time.
Okay, well then what I will do is look for your hopefully announcement of settlement. And otherwise we will be in touch by email through Mr. Freehoff to let you know date and time that we would expect you to actually report by Zoom with a link to actually try the case. And I'll estimate maybe an hour and a half, 2 hours if we need to go that route. Okay.
Thank you.
Okay. Anything else y'all need from me?
No, can we be excused, Your Honor?
Yes, you may. Have a great day.
Yes, ma'am. Thank you, ma'am.
Okay. And then Mr. Ratliff and Mr. King. I'm sorry, Mr. Faber and Mr. King. So I have been provided with your pretrial order. Thank you. So let me first start with this. I am not going to consider anybody's summary judgment motions. Okay. Number one, the original summary judgment motion that was filed is moot because it was filed as to a counterclaim that has now been voluntarily dismissed. And the subsequent summary judgment motion that I think was filed twice was filed by the defendant well after the date that the time had passed. But not only the time had passed, but a date after which the court had specifically said that the deadline for summary judgment was passed and that it was not going to be reopened or extended in any way. And so if that means I end up going through, I mean, this is technically a jury trial that the parties have requested. And so if that means I end up granting a DV after y'all have gone to the trouble to present a whole bunch of evidence to the jury, then so be it. But I'm not going to consider summary judgment motions that were not timely filed. It just is what it is. So that means that we need to address the pretrial order and when and how long you think it will actually take you guys to resolve the underlying case, which at least to my way of thinking is I know there are a lot of causes of action, but at the end of the day, this really is a case about an allegedly tampered with or improper VIN plate. I mean, that's really all it is. And then assuming that can be proven, what are the reasonable damages that would be recoverable under the various theories that the plaintiff has urged? One thing I was a little confused about is that I saw that an amended complaint had been filed just in the last few days. I would assume on the day of the pretrial orders being due. And there might have been some factual matters that I'm not as familiar with the particulars as y'all are, but in terms of the causes of action, everything looked the same. Can you educate me about why it's an amended complaint at this late date?
Yes, Your Honor. So there was an additional code section that was added to the negligence per se cause of action. That was the only change. There was a paragraph or two, and we did circulate a red line version to Mr. King as well, outlining kind of what those differences were, but it was just the addition of one section to the negligence per se cause of action. Okay.
And so how long do we anticipate it is going to take to actually try this case?
From the plaintiff's perspective, I think we estimated a day or two, and I think Mr. King's position was it would take slightly longer.
Okay, Mr. King?
Judge, I don't think there's any way we get it done in a day.
Okay.
A jury, I mean.
Well, I mean, the minute you say jury, I don't think there's any way you're getting it done in a day, period.
I tend to agree.
Yeah.
So if I were being realistic, I would say 2, but I always say 2 to 3 because things happen in trials. And so that's why I announced 2 to 3. I think if everyone's really efficient, 2 is the answer there.
Okay. Thank you. And same notice to you guys, once I figure out what my criminal calendar looks like, although typically what I do is my civil calendar week is the civil takes precedent and then the criminal backs it up. But I have to make sure that we're on board for that. But assuming once I figure out what the order is, it may be that you would be looking at maybe the 13th or 14th. So perhaps I would be doing the bench trial on Wednesday and then this 2-day trial on Thursday and Friday. But we'll have to look at that and we would give you more specific details about how we're going to actually try the case and when as we get a little closer next week. And of course, admittedly, because the criminal docket is so heavy, fully acknowledge that sometimes the civil cases they just get bumped by what goes on with the criminal. So hopefully that won't happen, but I'm just warning you that it might.
Judge, could just put in, understand the court's got to control its own calendar, but just a request to the extent possible, given the announcement of the bench trial case, if the court would consider possibly calling us in on the afternoon of the 13th, just to avoid us pushing into the afternoon on a Friday and a jury sitting out there. It always makes me nervous.
Yeah, if I did that, what actually would end up working better with how the jury works in Fulton County and how long it takes them to get everybody processed and ready to go would actually make more sense to call you guys in to pick your jury on the morning of the 13th. And then once you get your jury, send everybody home, try the bench trial in the afternoon of the 13th, and then start fresh with the jury with openings on the morning of the 14th.
That'd be fun. I just was getting concerned about a Friday afternoon, as always.
No, I don't blame you. But as long as we stay away from the Friday before Thanksgiving, then we should be fine. That's a hot plate that we do not want to touch. Jurors hate that. So, okay. And are there any other issues, questions, et cetera, regarding how I conduct the trials? Obviously, you can reach out to Mr. Freehoff. I think the main things I would let you know is that we use Zoom to share evidence in the courtroom. And so that means that each day that we have trial, we will provide you with a Zoom link. And to the extent that you want to broadcast evidence to the jury, it will be by sharing your screen in Zoom. You still need documents, though, in paper, because you're going to need your witness to identify that document unless, which I love, y'all get together and say, yep, all these documents are just coming in. Let's all agree. And then that saves everybody. I think probably save, depending on how document heavy the case is, it probably saves everybody at least an hour per trial. If we can just all agree on what the documents are and only fight about the ones that are actually an issue. Beyond that, you'll have 36 jurors. Y'all will need to let me know before we start picking jurors if you will agree to only pick 12. And then if you lose one, go forward with an 11-person jury, or if you want an alternate. And those are all just, I think every judge has their weird quirks about different ways that they do it. Any other questions or anything in terms of procedure that you can think of you have, Mr. King or Mr. Faber?
Briefly, Judge, my understanding is you want our jury charges and our voir dire by Friday or Thursday, I guess, today.
Voir dire is the primary, right? That's the main thing. Just to, and really it's just to make sure that y'all don't have any major outlying problems. So really the reason I'm asking you to send it to me is so that the two of you will see it and y'all can say, hey, I have a problem with this question. I don't intend to go through it and grab or make an assessment unless one of y'all brings it to my attention. The only thing I reserve the right to do is say, yeah, I've already heard that question 3 times. We're not asking it again. I try very hard to let you guys charm your jury to the extent you wish to and pick the jury that you want. So that's fine with me. And then as to the jury charges, the main thing is I typically prepare my own jury charge. And so what I'm looking for is just a list of the patterns and then the substance of anything that is a non-pattern charge, including 2 citations, gold star if it's a citation showing where it was used as a jury charge, but certainly case law that indicates that it's an accurate statement of the law. And the reason I do that is because I will typically prepare it into one PowerPoint and then give it to everybody so we can have sort of preliminary as we go discussions, so we can figure out which ones are actually at issue as the evidence gets to a close.
Okay. But you want because it's a weird week, we're starting on Wednesday.
Right, and that's why I was saying, as long as you get me the jury charges by the start of the trial, that's fine. But voir dire, I really do need a little bit ahead of time.
So would Friday work?
Yep.
Okay. Thank you, Judge.
Anything else, Mr. Faber?
Nothing, Your Honor.
Nothing else, Mr. King?
Nothing further.
Okay, well, we'll be in touch with an exact trial date, but tentatively, we'll be looking at the 13th as a jury selection day. And like I said, we'll be in touch if that's not going to work. Okay.
All right. Thank you, Your Honor.
Thank you both. Have a good day.
All right.
Okay, Mr. Newby, Ms. Hackett. We are ready to go on the Girls Galore versus the City of Atlanta. One question I do have is, I see a court reporter. Is that court reporter to take down this matter or a different matter?
Your Honor, I made arrangements to have the court reporter take down this matter.
Excellent, Mr. Newby. So, Madam Court Reporter, for your benefit, I'm going to formally call the case so you know it's ready. We're ready to start. This is going to be a hearing in the matter of Girls Galore Incorporated doing business as Allure Gentlemen's Club versus the City of Atlanta and Mayor Andre Dickens. Case number 24CV010553. I'll note for the record that this hearing is taking place by video, remotely by Zoom. I'll also note for the record, for the benefit of everyone involved, is that this matter is also being live streamed. So congratulations, you're all influencers. But that is in order to satisfy our obligation to have open courtrooms. And so it is being live streamed. One reason I mention that is that although you may be able to view this later, it is not the video recording of this, to the extent it exists, is not an official court record or an official record of this proceeding, which is why, Mr. Newby, I was pleased to see that you had a court reporter. So with that, I will ask counsel for each of the parties to identify themselves, and then we'll get started, starting with Girls Galore.
Good morning, Your Honor. My name is Attorney Ken Newby, counsel for the petitioner Girls Galore.
Thank you. And who do I have on behalf of the City of Atlanta and Mayor Dickens?
Good morning, Your Honor. Tracy Hackett, appearing on behalf of the City of Atlanta and by special appearance on behalf of the Mayor, Andre Dickens.
Okay, thank you very much. So, Ms. Hackett, this is technically your motion, and well, there is a motion by Girls Galore to require the production and transmission of the official record of the lower judicatory that's pending. But there's also still pending a motion by Mayor Dickens to be dismissed from the case, which I as I understand them, and then y'all can educate me and tell me if I'm understanding them wrong, but I feel like they're sort of the two sides of the same coin, because ultimately the dispute here is who is the lower judicatory that is responsible for maintaining and transmitting to this court the official record of the proceedings below. I think it's worth mentioning that the only reason I'm even remotely familiar with how the License Review Board, I think they refer to it as the LRB, even works, is I think because of a prior iteration of these two parties, I think, related to another issue associated with Allure Gentlemen's Club's license. But now the issue seems to be whether, I think in the email traffic I saw, there was some agreement that the LRB, well, let me leave it there. City of Atlanta has been sued and served, I think there's no dispute. Mayor Dickens has been named, and I don't think there's a dispute that he's been served. There is a continuing dispute that he is not a proper party to this action. And that I think the city's position, that Mayor Dickens' position is that either the city or the LRB are the appropriate lower judicatory for purposes of transmitting the record and for being sued, and that Mayor Dickens should be dismissed. Is that roughly in a nutshell, Ms. Hackett?
Yes, Your Honor, that's roughly in a nutshell. But I will point out also, Your Honor, what has happened since the email exchange is that the record has been filed.
Okay.
So that should no longer be an issue. I believe it was filed at 5 o'clock yesterday evening. I'm looking at a receipt that was received. So
okay, and it just hasn't been updated. It hasn't been
Right.
accepted, so I can see it in Odyssey yet, but I trust that if you're representing that it was. That sort of begs the question though, who filed the record?
So, Your Honor, the record was filed by the advice and counsel for the LRB.
Okay. Okay.
As we try to work through this issue.
Okay.
Because that has been, quite honestly, the issue. And if you look at the record, and I'll just start there, Your Honor. If you look at the record, when the petitioners initially filed their petition for review, there are about 4 or 5 different certifications of service that were filed. The certifications of service that were filed by Mr. Newby indicate that they served it upon the mayor in his suite. And it was sent via, I think, U.S. Postal Service. Then there's another certification of service where the process server served the actual petition of review to the law department. And so we accept service of complaints. So we did accept service. That's where we are. We accepted the service of the actual petition for review because according to the new process, the petition of review process that was implemented in July of last year, the corresponding municipality is the person to accept the service.
And let me just say, Ms. Hackett, how much I appreciate the fact that y'all did do that, because there's nothing that drives me crazier than listening to parties argue about, well, they didn't physically put it in my hand, so I haven't been served. I appreciate it when y'all are just like, fine, whatever. And now let's argue about the substance. So thank you very much for that, Ms. Hackett.
You're welcome. So yes, so we did agree that we did get properly served with the petition for review. The question still remains, and as you're aware, Your Honor, this is different because in this particular case, unlike our other boards and commissions that we have in the city of Atlanta, the License Review Board makes recommendations to the mayor. And the mayor is the actual one who issues the final decision. So in this case, they're appealing the final decision that the mayor did, even though the board conducted the hearing. So the
board, but isn't that actually Mr. Newby's argument though, that ultimately, because the board only has authority to make recommendations, which can either then be accepted or rejected by the mayor. So in other words, the mayor's decision is the final decision, that they aren't a judicial or quasi-judicial body for purposes of being a party or for being responsible for transmitting the record.
And that's correct. And so the process is, if we accept that the mayor was the lower judiciary for purposes of the license review board, then Mr. Newby needed to serve the mayor, because they're not the law department, because there is someone assigned to accept service of the actual appeals of the final decision. And then they would have knowledge to send up the record, which is where the kind of conversation came in, because the law department here, we do not have the record, right? So we do not send up the record. So, and then because service was not made upon the board either, they did not have knowledge to send up the record, which is different.
Board, but one of the problems
they would not have been.
Right, is that the board isn't, even though it's a thing, right, that we all acknowledge exists and is doing important work on behalf of the city, it's not an entity. As I understand Mr. Newby's argument. I mean, maybe I'm wrong about that.
The board is established by our city code, and it's section 30-26. And what I have conceded, and we mentioned before, unlike our other boards that do make final determinations when
the zoning board and things like that,
right? Our water and sewer boards and all other boards. In this particular case, the mayor makes the final decision and makes his own independent review of the record, right? So in this particular case, then if Mr. Newby in the code talks about the statute talks about service upon the lower judiciary within the 5-day period to let them know that there is an actual appeal of his decision. That's the part we're saying did not happen. But and we just decided to move the case along to go ahead and have the license review board send up the record on behalf of the city. But the normal procedure, Your Honor, is that there are two separate kind of things happening at the same time. And ultimately, it is the mayor in this case who is the lower judiciary. And the lower judiciary should have been served also with the petition for review. And then the city, by and through the law department, accepted service of the complaint itself, which is what we do. So it is one and the same, but it's separate, because there is a mechanism in place. And if you look at the code, it has two different things here. So it talks about the lower judiciary and service upon the lower judiciary. And then there's a separate section in the statute that talks about service of the petition to the corresponding municipality. So they're not one and the same. The code makes a distinction. So we're saying that we accepted service on behalf of the fact that you're suing the city of Atlanta, and that's the corresponding municipality, right? And so we did accept service of the petition versus the city of Atlanta. We're also saying that because the mayor is the lower judiciary in this particular instance, that he's not the proper party to have been named in here, because the code, the petition for review as revised, say that if the only thing that the official or lower judiciary has done is to render the decision, they shall not be named as a party. So they should not have been named the mayor in his official capacity as mayor in this instance, because he is serving as the lower judiciary in this particular instance. And because he's serving as the lower judiciary, then they should have served the mayor's office, where they have a person in place that would send up the record. That never happened. They served the city, being the law department, with a copy of the petition for review. They didn't simultaneously, within 5 days, serve the mayor. And that's where the confusion on our end came, because if you contact the mayor's office, they did not receive the petition for review to send up the record. If they had been served with it, they would have sent up the record. And that did not happen. We do have a statement from Mr. Newby in the record where he certified that he mailed it via U.S. mail to the mayor and his suite. And I think it said 2400. We don't have the proof of service that was done. We have that, but what our records show that we don't have anyone who could verify that I actually went to suite 2400 so they would know to send up the record.
Okay.
But to move the case along. Okay, go ahead, Your Honor.
Well, and I appreciate that, but I think part of where I'm confused, and maybe Mr. Newby will address that in a few minutes, but the original briefing that I saw was that Mayor Dickens just wasn't a proper party at all. He should just be dismissed from the case, not because he wasn't served, but because he didn't have anything to do with anything, and this is all about the LRB. And so when you combine that confusion with some effort at notice to the mayor, because he's the one that signed the letter taking the official action about which the appeal is urged, and then you combine that with the fact that the entire purpose for the unified appellate rewrite was to get rid of these, I'm sure, especially you guys in municipal law, right? The hole that ended up getting dug with all of the writs of certiorari and whether a bond was issued and who was the respondent and who was the defendant and all that good stuff. Part of the entire purpose of the unified appellate structure that was adopted in July of last year was to get rid of those issues and try to more correctly get to the nature of the substance.
And I would agree with you, Your Honor. And that's actually the city's position. If it had been served properly, we would not have had to spend this time looking for documents, looking to find out who was served. And so that took some time because it was not, and you're right, I initially, when I filed my cross motion, thought it was the LRB because the first two, this is a triology. This is the third time we're before the Superior Court. The first two times was under the old way we were doing it. And so the LRB was the person, the entity that was sending up the record. Now we have the new unified petition for review process because there were three parties that were named. We had the petitioner, the respondent, and then we had the person who was responsible for sending up the record. I think it was the defendant. And now we just have the petitioner and the respondent. And so now the question is, and that's why I said I concede that it is not the LRB. The LRB is not the person in this particular instance, which would be responsible for sending up the record. And even when we asked them to do it, because you asked, Your Honor, who actually sent it up, we had the LRB send it up because they were the one who heard the matter. But the mayor was the one who actually made the final decision. So even internally, we're just trying to figure that out because the certification or what you have now filed came from the advice and counsel for the LRB, who technically are not the lower judiciary in this instance, but we at least wanted to get the record sent up. So I would agree that it was intended to clear up some confusion, but here, what we really wanted to do is get the case heard on its merits. So in order, and I appreciate you saying that, Your Honor, instead of us going back and forth of who should have been served or how to serve, and since we have the record, and I would also like to point out, Mr. Newby also had the record because he attaches the transcript to his petition. So
but we all know that the only certified record that the court's supposed to consider is from the lower judicatory. There's just an open question about who and how that was. So
and so right now, what you do have filed that is not, I guess, processed yet is the record that was sent up from the advice and counsel from the Labor Review Board. That's what we have filed.
So before I call, last thing, Ms. Hackett, before I call on Mr. Newby to respond. So it sounds like that one side of this coin has been addressed in that the record has been filed, right? That was one side of this issue. And then the second issue was really the heart of your motion, which was a motion to dismiss the mayor.
That's correct.
So help me in a paragraph, if you can. Tell me what the relief is that you seek, and is the relief that you seek dispositive of the substance of the outcome here?
No, Your Honor. I mean, the relief that we seek is to have the mayor removed as a party, which is what's required under the petition for review statute that was revised in July of last year. It says that the person who renders that decision shall not be named as a party. And it actually says that the court can do that on its own motion. So here, we're not saying that it's dispositive of the case. The city is saying that if we are willing to submit to jurisdiction, and the case should be captioned Girls Galore, Inc. doing business as Allure Gentlemen's Club petitioner versus City of Atlanta as the respondent. The mayor should not be named as a party.
Okay, but your position is that removing the mayor doesn't change the substance of the case, and that Girls Galore would still be entitled to pursue its appeal and substantive review of the decision that was made, removing its license, even without the mayor as a party.
That's correct, Your Honor. And that has happened in many cases, especially in light of the recent change. Well, not so recent now, but the change last year.
People still say the new evidence code, and that's been around for like 15 years. So,
Right. So the city's position is the mayor should not be named. And that's what it says in the statute.
Okay. Thank you very much, Ms. Hackett. And Mr. Newby, I'm going to call on you, and then Ms. Hackett, I will let you have the last word because it's technically your motion. So, Mr. Newby, please go ahead, sir.
Thank you for the opportunity, Your Honor. I'm going to first address these issue regarding the motion to dismiss, and then I just want to say something briefly on the record issue because I learned some stuff. The city has plainly admitted that the lower as I argued in my response, that the lower adjudicatory is the mayor, is not the license and review board. What that means, therefore, since the parties agree who the lower adjudicatory is, it gets very simple under the statute. The lower adjudicatory under the statute is the one that is required to transmit the record. They say the record has been transmitted in this case. We'll come to that in a second. But what they're really arguing now is that the mayor should be dismissed because they say that the mayor was not served in 5 days. Let's look at what the record shows, though. The record shows I actually went overboard, Your Honor, because of the newness of the statute. The mayor was actually served 2 ways. First, the mayor was served by mail within the 5 days. She says there's no proof that this happened. Well, the statute that we're under, the new statute, says that a certification from an attorney as to the mailing is proof of service. And so that's exactly what I filed. I filed a certificate of service signed by me that identifies exactly what happens, like any other normal certificate of service, and that is sufficient service. But even if that wasn't sufficient service, I had a process server actually served the mayor as well. How? According to the process server's affidavit, which is also on file with the court, the process server went to the city law department. They acknowledged and accept service on behalf of the mayor. Now, counsel for is arguing that, well, they were only accepting service on behalf of the city. They were not accepting service on behalf of the mayor. But no one told the process server that, Your Honor, at the time of service. And the process server was quite clear as to who the service was on behalf of. And the affidavit of service that we filed from the process server also indicates that. So there's really no credible argument, Your Honor, that the mayor has not been served within the 5 days based on 2 different methods of service in this case. They say that, well, the mayor only made a decision in this case, and therefore they're not sure about the mayor being a party to this case under the statute. And there's 2 key points here on that one, Your Honor. The first is we're required to serve, because the mayor is the lower adjudicatory, we're required to serve him under this new statute. It is pretty normal and pretty consistent, I think, with the statute that if you have to serve a party and the court needs jurisdiction over that party in order to order them to do things, for example, like transmit the record, then they should be a party to the case. Secondly, the statute itself contemplates, even if the mayor is an official making a decision, being a party to the case. What the statute actually says, and the section of the statute I'm looking at, Your Honor, is OCGA 5-3-3. If you look at, this is the definition section. If you look at subparagraph 11, which is the paragraph that defines what a respondent is in a certiorari matter, it says specifically, except for reasons other than having rendered the final judgment under the review, the term respondent shall not include any judge, official, or member. What counsel is relying upon is the last part of the clause that says respondent shall not include official to argue.
Right, that means that you're not supposed to sue the individual members of the LRB or the individual members of the zoning commission, as I understand it.
I agree with you. Thank you. You took the words right out of my mouth, actually, Your Honor. So I agree. It means we can't sue the individual members of the License Review Board. We have not. It would also mean, I think, that the mayor in his personal couldn't be held responsible for anything. We're not seeking to hold the mayor personally responsible for anything that happened. But I wanted to just add, we also have claims in this case for due process and for equitable estoppel that we do think apply to the mayor in his official capacity acting on behalf of the city of Atlanta. So we even fit within the except for reasons other having rendered section of the statute based on the claims that we've actually filed. More importantly, Your Honor, leaving the mayor as a part of this case causes literally no harm, to the extent that it's ambiguous at all, or that it's unclear because it's a new statute. Allowing this case to go forward with the mayor as a respondent or as a party to the case only ensures that the court will always have a complete record because he's the lower adjudicatory from the decision that was below. Now, they say, and I can't really comment substantively because they said they filed the record last night. I don't know what that record that they filed included, but since I haven't seen it, but I do know the complete record in this case is more than a transcript and is more than what I had access to. I did file the transcript, but I understand there are also videos, for example, that the mayor based his decision on that were used, which would also be part of the record. And it would also be our position that anything that the mayor used or relied upon in making his decision, that constitutes part of the record from below, because we're reviewing the entirety of his decision. After all, the standard that's going to be governed for this review is a substantial evidence standard as to whether or not there was substantial evidence in the record to support the decision that he made, which is why you and I in the court and everyone needs to see the entirety of the evidence or the record that the decision was based on, and why it's important that it's certified that is what it is, so that when I start making arguments about, hey, well, this was not, the mayor didn't make his decision upon this because it wasn't included in the record, and therefore the decision should be reversed, I can be able to make those types of arguments, and Your Honor can be able to review the record and reflect and see, okay, this wasn't in the record, and maybe he made a decision based on something that wasn't in the record, which then would clearly be improper. And so this record stuff, this lower judicial stuff is very important. I think the court should not dismiss the mayor at this time. Essentially, that you asked two very poignant questions. You asked the city, well, is this dispositive of whether or not that we include the mayor or not in this case? And she's basically said, no, the case should continue no matter what. But she could not identify any harm to the mayor either of allowing this case to continue with the mayor. I would say there's a substantial benefit because the court needs to ensure it has jurisdiction over the party that's required to transmit the record, and and the statute requires.
Well, to that point, Mr. Newby, sorry for the interruption, but to that point, if we wait and make sure that you have a complete record, right? why do you require the mayor's presence to be able to fully litigate the decision, challenge the decision of the removal of the license?
Because we have two causes of action, Your Honor, that are not that are related to the mayor's decision, but they're not just the reversal of the decision. That cause of action is for due process, and that cause of action is for equitable estoppel, because we contend that there's a history here that is relevant to the case.
I'm aware generally, I think the equitable estoppel argument is that related to the fact that there have been renewals of the license at various points while the what's the word I'm looking for? Punitive adverse action as for the license have been taken. Is that roughly it?
That is, yes, it is, Your Honor.
Okay. And I know I addressed due process issues previously, but those issues, at least as my recollection of my order, were directed at the LRB, not at the mayor necessarily. But I understand your point. Anything else, Mr. Newby, that you want the court to address or mention as we're moving forward before I call on Ms. Hackett to make any rebuttal she would like to make on her motion?
Yes, I would like an opportunity, Your Honor. Assuming the record is even perfected by today or tomorrow, I would like to address the briefing schedule that Your Honor set, because I wanted to make sure I have a reasonable amount of time to prepare my brief after the record is fully perfected. So perhaps we can have a conversation about that timing. I was going to make it simple and short. I wanted to have until December 20th. In order to file the petitioner's brief. The reason for that is twofold. One, I still don't have the record as of today, and I've been dealing with some health issues, which we could get into if necessary. And then two, we have holidays and leaves upcoming. So essentially what I'm providing for is basically roughly a 30-day period from the time that I'm sure the record is complete, and then excluding the leave time, the court-approved leave times that are already on file. That's how I get.
Okay, thank you, Mr. Newby. Ms. Hackett, if you want to have the final word on the motion issue, and then if you want to, and then we can deal with the timing of substantive briefing and that sort of thing.
Yes, Your Honor. I would like to go back to the petition for review statute and look at 5-3-3, subsection 11. And subparagraph 11, where we have the definition of respondent, and we cannot take it in isolation. What it actually says is that the term respondent shall not include any judge, official, or member of the lower judiciary that rendered the final judgment under review. And then it says, if there's no party adverse to the petitioner, the respondent shall be, and then under subsection B, for quasi-judicial decisions rendered by a municipal official, board, tribunal, commission, authority, council, or similar body, the corresponding municipality. That's the city of Atlanta. The statute is clear that the mayor should not be a named party because he was the person who rendered the final decision in this matter. There is no justification and no support, and it actually says the opposite. It said they shall not be named as a party. So in this instance, case in point, the mayor should not have been named. He's not the proper party. The only party that should have been named as the respondent is the corresponding municipality, and that's the city of Atlanta. The city of Atlanta was served. The city has accepted service of the petition for review, and our motion to dismiss the mayor of the city of Atlanta should be granted, Your Honor. There's no justification. There's no harm to the petitioners by removing the mayor. And it actually says, as I mentioned earlier, the court can do that on its own motion. The mayor is not the proper party to be named here, Your Honor.
Okay. Okay. So I think that although it hasn't been tested, right, that I've seen so far, I have always understood that provision to be directed at not suing an individual member of the Public Service Commission or an individual member of the Planning and Zoning Committee or something like that. But your point about the mayor as a municipal officer making a quasi-judicial decision, which clearly I think this meets the definition of, that the appropriate adverse party is the municipal entity, the municipality. But that also assumes that there is no party adverse to the petitioner. And I think, as I understand Mr. Newby's point, at least for now, there are two reasons he thinks that the mayor should stay. One is that until the record is complete and clear, and until we all agree that the lower adjudicatory, the mayor in his official capacity, has perfected that record, which would be their duty under this statute. That's number one, why the mayor should stay in the case, at least for now. And number two, as I understood Mr. Newby's argument, is that his position is that because there are other reasons other than having rendered the final judgment, that the mayor should stay in. Primarily this argument about equitable estoppel and this argument about some sort of lack of due process as it relates to the procedures that the mayor uses. I'm not sure that wins the day. But for now, what I'm going to do is I'm going to keep the mayor in at least long enough to make sure we can all agree that a full record has been transmitted. As you know, Ms. Hackett, we can't see that it yet. It's been filed. I have no doubt of that, but it's not been accepted by the clerk. And so I have no way of seeing it. Mr. Newby has no way of seeing it. Once it's received, I think it sounds like Mr. Newby is going to have some arguments about the nature and extent to which it is a complete record. And if there's an issue with it not being a complete record, then there is an argument that the mayor, only in his official capacity as the lower adjudicatory, would need to remain long enough to make sure we have a complete record. At that point, I think then the court will have to decide, but is probably persuaded that absent some unique circumstances, the mayor probably doesn't need to be here for the appellant to receive full and complete relief. So here's what I'm going to do. And this also is going to go directly to this issue of the briefing stage. So Mr. Newby had asked for until December the 20th to file a pre-hearing brief. And then of course the city would have an opportunity to file a responsive hearing brief, and then we would have a substantive hearing. I think that sounds reasonable, Ms. Hackett. On what are your thoughts on the reasonableness of that proposed timing?
Your Honor, that does not work for my schedule. However,
okay.
I'm actually have leave of absence put in at the end of the year, the second 2 weeks in December through the end of the year. So I will not be able to receive that. Also have a Supreme Court argument in the first week of January. So the schedule that we have now in place works for my schedule, but I do understand the need of Mr. Newby. I know he mentioned some health concerns. Your Honor, here is the other thing that we have. It feels like, I know we extended it this time. At the present moment, it has operated as a stay on the decision to revocate this license. And as long as we keep extending it out for various reasons, the city still has this establishment that is now open that has caused a lot of heartache, and I'm using that word mildly, for the city. So I cannot consent to extend it out to infinity over the holidays when this establishment, clearly it is the intent of the city to have this establishment shut down permanently. Well, I understand Your Honor is going to review that.
I understand that, and I sympathize, Ms. Hackett, but also it's worth noting that one way to have sped up this process would have been to have, filed the record like a month and a half or 2 months ago. Just saying. I understand there was a dispute about whose responsibility that was, but one way to have sped up this process to enable the appellants to have their day in court, and then if it's affirmed, if the city's decision is affirmed, to get the relief that the city wants, right, which is to revoke that license, would have been to get that record filed. And that's really my concern. So I've heard your concerns. I'm particularly sensitive to the day-to-day issues that you're dealing with in terms of, it's the holidays are coming. It sounds like you've got an argument you've got to prepare for in front of the Supreme Court. All those things are important, and I understand them. But I also, here's what I had anticipated doing based on what I've heard from all of you is Mr. Newby had requested until December the 20th to file a pre-hearing brief. Today is only November the 7th. And so one of the things I was considering is having by, hang on, I've lost my monthly calendar that I was just looking at. There we go. Having by Friday the 15th of November, the deadline for Mr. Newby to advise if he believes the transcript, that the record from the lower judicatory is in any way incomplete, and for y'all to address that issue. I'm not inviting briefing on the issue, but basically what I'm looking at is a hard date by which, if Mr. Newby believes that the record is incomplete, that he will have by then notified the court, reached out to you and said, hey, I think this should be in there. Why is this in there? Can y'all send it over to me? Now, assuming that the record is complete, then having him get roughly 35 days, which we all know it's not really 35 days because there's Thanksgiving in there and then there's Christmas in there. Well, I take that back. It would be before Christmas, but that would still give him about 30 days to file a pre-hearing brief. And then I don't want to, I don't want to be unreasonable, Ms. Hackett, but, in an effort to accommodate the issues that you have going on obviously in terms of the holidays, I was willing to give you some additional time, but then I question whether you actually want that additional time because of the concerns about enforcing it. So setting all that aside, what I would likely do is impose a November 15th deadline for everybody to agree that the record is complete, or to let me know what's missing, that the city is saying, no, we won't give you, or no, that doesn't exist. And that doesn't mean I'm going to order anything one way or the other. We'll all be operating in a universe where we know what exists and what the city is saying doesn't exist, right? That's number one. And then I would give Mr. Newby the requested December 20th to file a pre-hearing brief. And then my intention would be to give the city until January the 24th to file its response brief, because that's a little bit longer than 30 days. I could give you more time, but I know it doesn't sound like you want that. And then the benefit of having that briefing schedule based on that is that then the first week of January, probably the 6th of January, but I can't swear to that, would be the actual date for a hearing in this matter substantively. And so I'm sorry, February 6th. I said January and I meant February. So we would be looking at November 15th for the record, December 20th for completed pre-hearing brief from the petitioner, January the 24th, or we could even push it to a few more days later if you wanted into that next week because of the Supreme Court argument and your leaves. And then we would be prepared to have the actual substantive hearing the first week of February. Ms. Hackett, what are your concerns? If there's a way that I don't know how I can address both concerns at the same time. Give you enough time to prepare substantively versus also not unnecessarily delaying the stay, right? Unnecessarily extending the stay that is in place that allows this party to continue operating.
Your Honor, if I look at the original briefing schedule, it was due November 18th, and my response was due 30 days later, correct?
Yes.
And it would have been, our hearing would have taken place January 9th.
Right, that sounds right. And essentially we'd be moving it back by a month because whatever record, there was no record. I understand your position that Mr. Newby was representing this party at the hearing, or at least has the transcript of the hearing. But the record was not officially a part of this court's record until, I guess, today.
Is there a way to have the hearing? Because I know you sooner than the date that Your Honor is proposing, even if that shortens the time period for my response. I really do not want to go into February.
I can have it in January sometime, but that would necessarily, over the holidays and with everything else that you've got going on, shorten the time for you to respond. I mean, the only week I would not really be able to do it would be the week of January the 20th. But I could probably do it the week before that. But that would mean that the city would be looking at, less than 20 days to respond. And I don't know which one's the trade-off for you personally and for the city.
January 24th.
For example, I could have this hearing on the 17th of January. And then that would mean that you would have until, realistically, to make it not unreasonable for Mr. Newby, I could give you until the 13th or 14th of January to respond. But also,
unfortunately, like you said, I'm a sort of between a rock and a hard place.
I know. I mean, I know you have a lot of capable attorneys that can assist you, but at the end of the day, it's your name that goes on the briefing. So I understand that you want it to be addressed. And the other issue about having that hearing on that Friday is that the following Monday is a holiday, and I don't know the extent to which people have, holiday weekend plans and things like that. So, I mean, I know it's not the city's preference, but all things being equal, to give the city the best ability to respond to the arguments that Mr. Newby's going to make, I mean, it seems to me that other than the delay occasioned by their continued operation and my promise to give you guys a ruling as quickly as I can, that then the parties can act upon, it does seem to me that the most logical thing to do is to give the city until, the 27th of January and then have the hearing that first week of February.
That's fine, Your Honor.
Okay. So we're going to issue a new hearing notice and briefing schedule. And just to be clear, so everybody's on that, it will have until any complaints about inadequacies in the record. Again, I'm not intending to rule on it. I'm hoping y'all can work it out by yourselves. And I suspect that if you can't, it's going to come down to that doesn't exist or we don't have it. And y'all can document those things. But I just want some record by November the 15th that the parties are in agreement that the record is complete, or that one party or the other says such and such doesn't exist or there's some inadequacy. Yes, Mr. Newby?
If I have the record, or what they filed as the record tomorrow,
yes, sir.
I'm not going to wait until November 15th to reach out to them to let them know that there are any issues. I'll be in touch early next.
Yeah, I expected that you would. Thank you. But, and so that would be November the 15th. And then Mr. Newby will have until December the 20th to file a pre-hearing brief. And then the city will have until January the 27th of 2025 to file their response brief. And then this matter will be heard by the court. Because I think this is going to take a little bit of time, like in terms of the actual hearing that we'll need to have. It may be that it's going to be on the 7th, which is a Friday, instead of the 6th, because I usually keep my Fridays. I try to keep them open for longer hearings where I need to set aside. But we will take a look at that and give the parties a clear date, but it will either be February the 6th or February the 7th. That will be the hearing date.
And Your Honor, just if I may real quick.
Hang on.
Have not, I'm sorry, I can't hear.
No, that's
Because you
okay.
have not
Mr.
ruled-
Newby was trying to say something. Go ahead.
Okay, I'll let him go.
Yeah, I was just going to point out, Your Honor, that February 6th works, but I have a leave in on February 7th.
Okay, well, then it may be that y'all's hearing is going to be in the afternoon, possibly. But we'll make sure it's on the 6th. Okay. Ms. Hackett, what was your question?
Yes. Because Your Honor has not ruled on our motion to dismiss the mayor yet, depending on, I believe you said the accuracy or the completeness of the record, as well as maybe, I don't know if you said it depended on the brief as well.
No. What I said was that I understood Mr. Newby's argument to be that the mayor needed to stay to get the record complete. And then he also argued that he had these separate claims that directly related to the mayor. And what I was saying is I agree with him. The mayor needs to stay until the record is complete, but I'm not persuaded necessarily that he needs the mayor to be able to argue the equitable estoppel and due process claims. And so part of what I'm looking for is once I know that the record is complete, absent some unique other issue, my intention would be to allow the mayor to be released from the case.
Thank you, Your Honor.
Okay. Do y'all need anything else from me before we adjourn and I send you guys a new briefing schedule and hearing notice? Mr. Newby.
No, I think that's it, Your Honor. Thank you very much.
Thank you. Ms. Hackett?
No, that's it, Your Honor. Thank you.
Okay. Excellent. Thank you all. Have a good week.
Thank you. You too.
Okay, for those of you who are here on the Davis versus Schmidt matter, if you guys can give me about 5 minutes to get a little bit more coffee, and then I'll be right back and you guys will have my undivided attention. Hang on just a few minutes, okay?
Your Honor, before you leave,
yes, Ms. Perkins-Hooker.
Yes, ma'am, Your Honor. There were cases that were noticed to be here for the hearing that you didn't call this morning, and I didn't know.
I'm so sorry that you had to wait this whole time, Ms. Perkins-Hooker. I'm so sorry. So yeah, all I can tell you, Mr. Freehoff may be able to give you better information, but typically what happens is we start with 7 or 8 cases and then they get culled down because the parties announce resolution. As far as I know, every case involving the city of Atlanta, except that one I just heard, was resolved and removed from the calendar. I'm so sorry that you had to stay. I just assumed you were here on the other matter with the city.
Attorney Hamilton, we didn't know what happened in the Jones case, Jones versus Cummings.
Yes, so Jones versus Cummings announced settlement between the two of them in the sense that I think I understand that Mr. Jones is going to sell the property, or the Kellum investment people are taking that title. And so the parties have announced a resolution where Mr. Jones won't have title of the property, but neither will the city, right? At least as I understand their announcement. And so my understanding was that the parties had announced a complete settlement. The city of Atlanta was only in as a necessary party associated with their prior ownership of the abandoned alley.
Okay, so can we have our motion to dismiss the city granted? Because we're not a part of that settlement agreement.
Yes, so I'm not officially granting your motion, but let me have Mr. Freehoff confirm with the parties that was their understanding. And then why don't you send me a proposed order on your motion to dismiss? And assuming that what I understood to be the party's announcement is the party's announcement, then I would agree with you that the city is entitled to a dismissal, and I would go ahead and enter that dismissal if the parties don't voluntarily do it for you.
Thank you very much, Your Honor.
Thank you. And again, I'm so sorry that y'all had to sit through the whole thing. I apologize. Thank you. Have a good day.
As well.
I'm gonna take that break real quick and I'll be right back with you. Okay. So I think I also see a court reporter for this matter. So Madam Court Reporter, to make your job easier, I'm going to call the case and we'll go ahead and get started. This is going to be a hearing on defendant Barbara Schmidt's motion for attorney's fees pursuant to OCGA 9-15-14. The case is Gary Davis and Maribeth Davis versus John Doe, the Phoenix on Peachtree Condominium Association, and Barbara Schmidt. I'll note the case number is 2023 CV 374511. I'll note for the record that as the court understands it, this matter has been fully resolved in that all of the underlying substantive issues have been resolved, but that relative to the Davis's suit against Ms. Schmidt filed a long time ago. Mr. Crimer indicated, I think about a year ago, a motion for attorney's fees pursuant to OCGA 9-15-14. And that matter is now ripe. Arguably might have been ripe longer ago than now, but it is ripe now. And let me start by asking for announcements on the record. Can I have counsel for the Davises, please?
Heather Brown, attorney for Gary and Maribeth Davis.
Thank you. And counsel for Ms. Schmidt.
Good morning, Stan Crimer for Barbara Schmidt.
Okay, thank you. And also I'll note Mr. Wagner, Brandon Wagner is present, and you represented the Phoenix on Peachtree Condominium Association. But my understanding is the underlying case was adjudicated as to Ms. Schmidt, but it was voluntarily dismissed by the Davises as to the Peachtree. Is that correct?
That's correct, Your Honor. And there was also a cross claim filed by Ms. Schmidt against the association, and that was also dismissed. I'm only here just to observe.
Okay, just making sure. Thank you, Mr. Wagner. So let me start off before we get started by saying this. Mr. Crimer, if you would like to perfect your record regarding the nature and extent to which the Davises are authorized to respond or rebut, given that there was no written response filed to your motion for attorney's fees, you can do so. But I'm going to tell you on the record that I agree with Ms. Brown that generally default is disfavored, and failing to respond to a motion, while it might indicate that you have no opposition to it, does not mean that you don't get an opportunity to make argument regarding that motion. And so, right or wrong, it is my intention to hear argument and allow Ms. Brown on behalf of the Davises to challenge the amount of the fee and the underlying basis of the fee that you are seeking within the confines of what I had advised the parties earlier, which is this is not a free-for-all. We're going to try and focus our issues. To that end, I will also say that I expect that I'm going to hear from both sides about the fact that, and y'all I'm sure have a better recollection than I do, but I recall that there was an issue associated with some discussions at settlement that ultimately didn't happen. And then there were admissions that were not responded to because the attorney for, I think, the Davises indicated that they thought there was a settlement, and then that sort of was clarified. And ultimately, I don't think there's any dispute that the court determined that those admissions stayed. And ultimately, the case was resolved favorably for Ms. Schmidt in terms of the claim by the Davises directly against her as to her responsibility for the underlying damage to this, I think, property inside of a storage closet, if I recall correctly. The reason I start with that is by saying, as all of you well know, the fact that a case was adjudicated in favor of one party or the other, while it is a prerequisite usually to an award of fees, it does not mandate an award of fees. There has to be something supporting a lack of substantial justification, a frivolousness, et cetera, of the claim. And so I just remind everybody of that so that we can use it as a framework, because there's no dispute that the admissions were what the admissions were, and that ultimately Ms. Schmidt was able to secure a full adjudication on the merits in her favor in this case. And that may mean that attorney's fees are merited, but it doesn't mandate that attorney's fees are merited. So that's the framework within which I address this, Mr. Crimer. And with that, I'm going to throw it over to you to make your presentation that you would like to make regarding your fees, entitlement, and reasonableness.
Well, great. Thank you. May I proceed?
Yes, sir.
Okay. Well, for the record, I'm Stan Crimer, and I represent one of the defendants in this case, Ms. Barbara Schmidt. And we're here today on our motion for attorney fees following the grant of summary judgment some number of months ago. And I think the court has a pretty good grasp of the facts. Couple of quick housekeeping and legal points, though, before we proceed a whole lot further. Again, as far as the failure to respond to our motion, we filed our motion for attorney fees following the very, very explicit and pretty resounding grant of summary judgment. Now, I think there's some important findings by the court in that grant of summary judgment that pretty much strongly motivate, if not demand, attorney fees. And I'll get to that in a minute. But again, in terms of the evidentiary proceeding this morning, the case law that I'm referring to is that the failure to respond to a motion precludes the right to present evidence. It does not preclude the right to argue. So I want to be clear on that. Certainly, Ms. Brown has the right to argue, and she can even cross-examine me. I'm not so sure about that, but I'm not going to object to that. Happy to do it. So again, she's welcome to argue, and I fully expect that. Just can't put on evidence. However, that being said, there's a secondary and equally important issue, Your Honor, and that's the failure to respond to admissions. You may recall that Ms. Brown the plaintiff filed a motion to withdraw those admissions, and Your Honor found that they lacked good cause to do so and denied that motion. And so, Your Honor, those admissions stand in the case. And I would suggest respectfully, Your Honor, that given all those admissions, I'll just cover a few off the top of my head, they had no evidence to support their claims. And you said that, Your Honor, in your summary judgment order. No evidence to support their claims. Well, that's 915-14A. No evidence at all. That no reasonable person could accept their claims because they had no evidence. And so I'm getting a little bit ahead of the game here, but that's letting the court give me a heads up where I'm going in this argument and in our brief. They're bound by those admissions. So with that being said, what are some of the key admissions that they made? Again, they're in your summary judgment order and they're in our request for admissions, all of which are in the record. But the gist of it is no evidence to support their claims. No evidence that Ms. Schmidt got into the storage unit. Your Honor's correct. This involves a storage unit in the basement of a condominium building known as the Phoenix on Peachtree, aka the Phoenix. And storage unit at issue in this case is designated as storage unit number 402. And to make a long story very short, there was some confusion as to ownership of that, which was not my client's fault whatsoever. But somehow or another, allegedly, some personal property items, which looked like children's memorabilia, teddy bears, children's toys, records, things of that nature, frankly, having not a whole lot of commercial value, but certainly sentimental value. And the Davises just sued everybody they could think of. They just filed a lawsuit and sued my client. They sued the Phoenix. They sued 2 or 3 other people, the prior owners of that storage unit, the Joe Docks. And it's important, Your Honor, I want to remind you and refresh your memory. I know you have a big caseload like all judges, but plaintiff's counsel just absolutely did not prosecute this in a correct way. Your Honor dismissed a couple of the defendants sua sponte for failure to effect service. And so I mention those things not to criticize Ms. Brown. We're all humans and we make mistakes. I'm not here to throw rocks at her, but I'm here really to support why we ran up $45,000 in attorney fees. It was because of constant, endless mistakes and problems like this. Moving along on this time frame here, we did early on try very, very hard to settle. I tried very hard to tell Ms. Brown in conversations, and they're all in my billing statements. We had numerous conversations, and I will say very pleasant. She was cordial and professional, and I have nothing but nice things to say about Ms. Brown. And I really thought we could work it out, and it just never happened. I kept waiting and waiting, and Your Honor saw every bit of this in the motion to enforce settlement. And you pointed this out, and I think it's important, and I think it will help you reach a pretty quick conclusion on what to do about our motion here. I finally sent an ultimatum after weeks and months of efforts to settle. And I said, that's it. I just can't wait any longer. If we don't have a signed agreement by X date, I'm filing a motion for summary judgment. We didn't get the agreement. I filed the motion, and Your Honor pointed out in your order granting our motion that Ms. Brown failed to respond to the motion and instead filed a motion to enforce the settlement. In fact, what she really filed was something else that is debatable. It was called an omnibus motion. And in that, it included a motion to withdraw admissions and also, Your Honor, a motion to allow a late filed response to the summary judgment. Why do I bring this up? Why? You denied every single motion that she filed. So again, this is why we're here today. It was just so unnecessary. And I'll take a short detour. Ms. Bobby Schmidt is the nicest person you'd ever meet. She's a very, very consummate professional, a real estate agent who does business in that building, the Phoenix. Her reputation is extremely important to her, her integrity, and to get sued for a lawsuit for stealing or taking stuff out of a storage unit is just appalling. So this was very important to her. And I really felt that we could get this resolved pretty easily, and it just didn't happen. Again, I keep coming back to your summary judgment order because it's the foundation of our motion this morning. You very firmly rejected any effort to oppose the summary judgment. There was just no basis whatsoever. Number one, based on the admissions, and number two, based on the late responses and so forth. That was not part of your order. But again, your order was very, very definitive and clear that there was just nothing to the plaintiff's case. So in that, Your Honor, let me just move on to housekeeping then. That's just some background and why we're here, and I'll highlight a few more things as I go along. But while we were waiting on the other case, I made a few notes here, hopefully to expedite my presentation. As is standard procedure, when we filed our summary judgment, our petition for attorney fees, I filed a supporting affidavit with all my time and billing invoices. And I would like to and then as time went on, and then she filed an appeal after that happened. Ms. Brown filed an appeal, and I wanted to comment on that. The appeal was, your order was affirmed without even writing an opinion. The Court of Appeals basically said that you wrote such a good opinion and it was so clear and definitive that no written opinion was required from the Court of Appeals. So they affirmed your ruling without even issuing a written decision. Following that, we renewed our efforts to recover on the attorney fees here, and we spent some more time trying to get that scheduled and getting ready. And I filed a supplemental affidavit about a week ago with some additional time and just getting ready for this hearing today. And so just for housekeeping, I think it's sufficient to state in my place, but I'd also move those affidavits into evidence as well. So they are part of the record because they've been filed, but I'd go ahead and move them into evidence and will save me the time of reciting everything that's in the affidavits if I can do that.
I don't have any objection to that. Ms. Brown?
I don't have objections to these statements coming in, but I do reserve the right to cross them on them.
Yes, I understand your position, and I don't know that changes it, but yeah. I mean, basically, I think what I'm understanding Mr. Crimer to be proposing is that he could state in his place everything that's in the affidavit, but he's already said it. And if it's admitted into evidence and part of the record, then you can cross-examine him on those issues without him having to actually sit here and state in his place everything that's already in the affidavit. Is that?
I have no objection to that, Your Honor.
Okay. Is that okay? Did I understand correctly what you're trying to do, Mr. Crimer?
Absolutely. Just in even simpler terms, just to save us some time and headache and moving through this. So the only thing I'll say is that everything in my affidavits, I carefully reviewed it while we were waiting for your first case this morning, double-checked it. I absolutely believe every single thing in there was reasonable and necessary to a defense of my client. I will say in advance, I can anticipate this. There were a couple of items that refer to talking with Mr. Wagner about cross claims against him, and I'll just simply head that off. All that was part of a legitimate defense. These were claims that needed to be raised just to protect my client. And so I'm happy to answer questions in a minute, but let me just give some numbers and I'll be finished then. That speeds up this whole process here. So under my initial affidavit that I filed last year back in October, it was 102.4 hours. And then I filed a recent affidavit last week, and to my dismay, pardon me, to my dismay, the last page of that invoice got lost in the scanning machine. So you only have the first page, but there's 2.2 hours in that page that I just filed. It's a longer invoice because a lot of it relates to the appeal time, but that, as you know, is not recoverable. So in that fourth affidavit, there's only 2.2 hours of time related to the motion for attorney fees. And last but not least, Judge, the third element of hours that I'll get in the record here, I've spent 10.9 hours in getting ready for today. Just quickly, just for the record, because it's missing my affidavit. On October 22, I swapped some email. Swapped some emails with Ms. Brown about attorney fees and dismissal of the case. 7/10 of an hour. Drafted a proposed stipulation to dismiss the case so that we could be here and still reserve jurisdiction. That was 2.2 hours. On October 24, I drafted a dismissal without prejudice with appropriate verbiage to preserve jurisdiction as to our motion for attorney fees, because, Judge, I was concerned about that if we dismissed our claims, I wanted to be sure that you retained jurisdiction. That was 1.2 hours. On October 25, I spent 3.5 hours to get ready for today, review your standing order and all the other local rules that require the hearings, to arrange for a court reporter. So like I said, Judge, all that adds up to 10.9 hours. The grand total of those undertakings is 115.5 hours. Quickly comment on a reasonable rate. Judge, I've been a lawyer 44 years, practicing lawyer 44 years. Like you, I started off with a big firm and then gradually moved on to different firms. But I've worked in big firms, small firms, medium firms, house counsel, you name it. Litigated attorney fees many times, including motions for attorney fees and other situations in bankruptcy court, reviewed attorney fees. So I'm very familiar with hourly rates. I can say that an attorney with my years of experience and background would be well in excess of $400 an hour. You've probably seen inflation. I'm sure Your Honor sees attorney fees every day. $400 an hour is very economical for a case like this. I also, Your Honor, might have noticed, and I commented in my brief, I gave Ms. Schmidt a reduced rate just because out of sympathy, and I just felt bad. I just gave her a lower rate. She was a friend of mine, and so the actual bills are lower than what I'm asking for. I think I billed her at $350 an hour, a slight discount, and I'm requesting $395 an hour from the court. I've cited a case in my brief, the Hindu temple case, which says that just because I give a discount to my client doesn't mean that the culpable party, in this case the plaintiffs, should be given the benefit of that. They should pay a reasonable fee, is what the statute allows for. So all that being said, that the math on that 115 hours times $395 an hour comes out to $45,525. And I think that's extremely reasonable for the outcome of this case and the results that were obtained. And I will reiterate and be done here. Well, I don't want to be too hasty on this. I do want to point to a couple of things. You found these are some of the findings you had, Your Honor, in your summary judgment order, that the plaintiffs filed a motion to enforce an alleged settlement agreement in order to avoid the deemed admissions. That's what you said last fall in your order. You also said that as a result of the admissions, the plaintiffs admitted, number one, they have no direct evidence to support their claims against my clients. Number two, their claims are based entirely on personal belief and supposition. These are findings, Judge, that you've already made. So I submit on that. And the last thing that's kind of interesting law here, my last two requests for admissions are verbatim recitations of the verbiage of 915.14 A and B. As you know, I'm sure from litigating these, A is mandatory and B is discretionary. And the verbiage of subsection A is that if no reasonable person could accept the claims being made by Ms. Davis or by the Davises. And again, quickly, I maybe moved too fast. The claims were that my client took stuff out of their storage unit. But there's no evidence to support that. None at all. Therefore, Judge, no reasonable person could possibly believe that. You would have to direct a verdict. There's no evidence to support that she took stuff out of there.
Well, just to be clear, and I understand your argument relative to Ms. Schmidt, but just to make sure, I mean, I thought I understood that it's not as if the Davises asserted that people maliciously were stealing things from their storage unit. It's that that unit was deeded to somebody else and then emptied out because the person thought they owned it and that all the stuff in there was able to be thrown away. I understand your point as to Ms. Schmidt, but I guess, I mean, I understand the way it's drafted is that these people stole the things that were in the property, but it was as a function of the deeds, I guess, not being properly separated out to reflect that which unit went with which property.
Yeah, your memory's terrific. That's mostly correct. And to be clear on the record, I don't think they actually accused anybody of theft per se, but it certainly insinuates that the language is kind of disingenuously couched that says that she allowed things to be removed. But again, however she put it, there's just absolutely no evidence to support that. And this is another point that you pointed out in your order. We gave an affidavit in support of the motion for summary judgment in which she stated that she never had a key and never had access. And as you said in your order, that affidavit was it's quote unquote stands uncontradicted. And so that's where we stand here today. And those are all findings of fact and why I just, other than my fees, I don't think we have a whole lot to talk about. I think it's very clear that there was no basis under subsection A to even have that lawsuit. You just don't sue somebody and hope you'll find some evidence to support it. You need to have some reasonable basis. And I've said this enough, you get it. Please, I invite you to look at the request for admissions. They're very comprehensive. I spent a couple hours putting them all together. They have no evidence. And I think that mandates a ruling under subsection A. But as you are well aware, there's subsection B, which says if there's a lack of substantial evidence, that's the standard for subsection B. If the court finds there is a lack, that their case, quote unquote, lacked substantial evidence, then the court may award attorney fees. And it's discretionary, but I will say again, for all the same reasons under subsection A, they didn't just lack substantial evidence, they lacked any evidence. They didn't have any evidence at all to support a claim against my client for the loss of things out of their storage bin. Again, I'm very sorry that happened, but there's no evidence to this day, despite a year and a half of the case and everything else, no one really knows what happened. We can kind of guess and speculate, but we don't know that. What we do know is there's no evidence to support a claim against my client. And I just, as a lawyer for many years, I just take offense to that. Just sue somebody and throw it up on the wall and hope you get some money or whatever. That's wrong. And that's why we have this statute. What the statute says is lawyers, you just can't run into court and sue somebody and hope you come up with some evidence. That's not what our law allows. And therefore, I strongly feel that we're entitled to attorney fees. I think that's about it. I've got the affidavits in. One thing that seems to always come up in these attorney fee cases, I read Christine Mast, you know, her over at I think Hawkins and Parnell. She wrote a wonderful 45-page or 40-page article on 915.14. And I reviewed that, of course, before this hearing. And there's a lot of litigation on allocation. And I'm sure I can I've done this several times. Ms. Brown's going to ask me, well, which was this necessary or not necessary? Whatever. Judge, everything I did was necessary in this case to defend my client. As I said earlier, I talked to Mr. Wagner about some things, but that was all related. Some things, compulsory counterclaims. You have to file counterclaims. I don't, it almost goes without saying, I just don't put things in here that are frivolous that I didn't need to do. Where these allocation cases come up all the time is when you have multiple count complaints and a plaintiff succeeds on one but not the others. Then you do need to allocate fees. But we don't have that here, Judge, where you're defending a case. Everything I did, and I double-checked when I did the affidavits, and I double-checked again this morning while we're waiting, everything was reasonable and necessary. So that's all I have. I thank the court for listening to this. I compliment you on your memory of it, because I know you have thousands of other cases. So that's remarkable that you can do that, and you're pretty darn accurate. And I'm sorry to the Davises, but I'm even sorrier for my client that she's had to go through this and paid me a lot of money, and that's not right. And so we're asking the court to award attorney fees and expenses, which, by the way, expenses were minimal. I think we had an e-file fee for $24, and we have a court reporter fee for today, which will probably be $150. Maybe I think we're splitting it. So, you know, conservatively $200 in expenses, I would say, would be reasonable. And we don't have to drive to court anymore and pay the parking garage like we used to. But you're too young for that. But I did that, and
I still remember having to park at the underground parking lot and hope your car was still there and not broken into when you got back to it.
That's if you were there at night for sure, but daytime wasn't so bad. Anyway, I think you got the numbers. Just be sure for the record, because I'm getting old and bad about this. 115.5 hours at $395 an hour is $45,525. And I think that was a reasonable and necessary amount of money to pay for the defense that I provided and the successful result as well. And roughly $200 in expenses for a court reporter and e-file fees. And that is what we're asking for. Okay. If you have any questions, be happy to answer them. Otherwise, thank you very much for your attention.
Thank you, Mr. Crimer. Ms. Brown, I assume that you want to cross-examine Mr. Crimer now, is that right?
I do.
Or do you want to make argument first?
I would like to make argument first. And to start, I'd also like to just note a few objections for the record on the issue of the hearing. First one, Your Honor, is I'd like to note for the record that this hearing, evidentiary hearing, was not noticed pursuant to 911.5, 911.6, and Civil Court Rule 6, which would require and give us the opportunity to have sought late filed evidence from the court if it was filed up to 24 hours prior to the hearing. Rather, this was a status conference that remained on claims that have been fully adjudicated or fully dismissed. And we received an email during my timely and allowed for leave that the court was going to hear the evidentiary hearing on the status conference calendar. I did respond to Mr. Freehoff asking if we could have another date because I was on leave through November 4th. And understood that the court's position was we are going to proceed with the evidentiary hearing today. So I just want to note that it was not done pursuant to a notice of an evidentiary hearing. And I note that because there's case law that would have allowed my clients to file late affidavits at the court's discretion, of course, for the court to consider whether they could have put in additional evidence on their claims. And I'll give the court a citation. A Forest Lake Homeowners Association versus Green Industries, Inc. That is 218 Georgia App 890. And I believe, not seeing the year very easily, but and that case,
tiny print's catching up with us, isn't it? That's fine. Case, as long as I've got the citation, I can find the case.
Right. And Your Honor, in that case, the Court of Appeals is addressing the issue of a late filed evidence, and the claim there, what the court was looking at was an affidavit that had not been filed prior to the hearing. But the court goes in and lays out that the trial court has discretion to admit late filed evidence. It does recognize that an evident, there's no per se waiver of or no default on a 915-14. It's looking at the content. It's comparing a 915-14 to the concept of a summary judgment, which would also allow submission of affidavits prior to the hearing for the trial court's discretion. We are not intending to put on evidence today because we were instructed that the hearing would be argument and with the exception of cross-examining Mr. Crimer, that was in the instructions we received. But I want to note that objection for the record. I also want to note just 2 case sites that confirm we do have the right to question Mr. Kramer and explore the reasonableness and necessity of the fees, regardless of whether a response was filed. The first one is Nesbitt versus Nesbitt, 295 Georgia App 763. And the second is Greer versus Davis, 244 Georgia App 317. And again, Your Honor, I'm just noting these to preserve for the record.
I understand. I'm not familiar off the top of my head with those cases, but I mean, I am generally aware of the argument you've made, which is why I'm allowing you to cross-examine Mr. So.
Right. And Your Honor, in listening to the presentation, I disagree wholeheartedly with many of his characterizations of this case and conduct, particularly by me. But I do want to address a few things. You know, his motion is essentially a prevailing party context. His argument is essentially, we won summary judgment based on deemed admissions, therefore we're entitled to fees. And everything I did because of that was reasonable and necessary. That is essentially the argument. And 915.14 is not a statute on the merits. It's intended for the court to review whether someone was abusing the litigation process. Were they bringing claims so frivolous or that lack such justiciable issues that nobody could reasonably believe them to be true? The inquiry there, Your Honor, is at the time you're bringing the claim. Mr. Crimer wants to say because were deemed to have admitted things later in the case, which I'll address the actual admissions as part of the presentation, but because those deemed admissions were made, that we violated the statute when we filed the lawsuit. So essentially he wants to just bootstrap, you technically admitted this, so now we're going to say you never had a basis to file the claim in the first place and there was never a justiciable reason to sue my client. I think that is not how the statute is intended to work. When you look at the law interpreting 915.14, it is to be a sanctioned statute. It is not a prevailing party, as Your Honor noted. And so at the time that the complaint was filed, there were allegations. In fact, there were factual issues as to who removed the property. It was admitted, and it was also admitted in the affidavit on summary judgment and in admission. So I'm not arguing anything contrary to the deemed admissions. But, you know, at the time, there's no dispute and never has been a dispute that the Davises owned storage unit 402. That Mrs. Schmidt represented the seller of a condominium unit 1501, and as part of her duties as the agent, inquired to the Phoenix about whether there were any storage units, wine lockers, parking spaces, whatever may convey with that condo, was given information that storage unit 402 in fact belonged to the sellers. It's also admitted in the pleadings that Ms. Schmidt then asked the seller to obtain a key. So there was evidence that she had at least access to a key. Now, she does deny that she took anything out of the storage unit, that, we're not making any arguments that there's, as to the evidence, as to who did it. But as Your Honor recognized, the complaint that the Davises brought were that this inaccurate information was given, their storage unit was improperly conveyed, it was cleared out of all of its contents. And the idea that we just sued anybody we can think of is preposterous. We sued the seller's agent, who was Ms. Schmidt. The sellers also had a power of attorney, in fact, a gentleman named Steve Marshall, and then a gentleman named Cameron Marshall, who we had information and belief was working with Ms. Schmidt and at the time, Mr. Marshall. Steve Marshall's deceased. He died just prior to the filing of the case, actually, I believe just a few months. So we sued the John Doe was his estate. The sellers, Your Honor, are located in Austria now. They live out of the country. We made diligent efforts to try to serve them. We were researching The Hague. We sent waiver of service packages. We attempted to connect with them through Mr. Crimer and his client to try to effectuate waiver of service packages. Mr. Cameron Marshall, we were unable to serve because we couldn't locate him. We attempted in Georgia and in Florida. We sent waiver packages. We did skip tracing. We couldn't find him to get him served. And I mentioned this, Your Honor, because of the point of we weren't prosecuting because we were just letting parties get dismissed. At the beginning of the case, Your Honor issued an order that we had 60 days or 30, I don't remember the timing, so I don't want to misquote the timing, but an order giving us a period of time to submit proof of service or the case would stand dismissed against those parties. There was no hearing scheduled. There was no printed.
Guys, y'all, listen, y'all don't have to characterize me what the import was of anything that I did. So my standard procedure, because sadly I run into it a lot, is people file suit and then they never undertake to actually serve anybody. And instead of letting cases sit there and sit there and sit there, it's my practice that after a reasonable time period when service should have been accomplished, to let everybody know, if you don't get the person served or you don't tell me why you're having problems serving them and ask me for more time, I'm going to dismiss those parties from the suit. It's a procedural process. It doesn't, I think, fairly imply any judgments or assessments I have made about the parties or about the parties' efforts to prosecute their case. Although, except in those situations where nobody ever bothers to sue anybody, to serve anybody, and then I'm like, yeah, you didn't really care about this case very much. So we can put a pin in that and move on.
Yeah, and Your Honor, the point there is just we chose to continue spending resources trying to track down people we couldn't find. So they stood dismissed. We had served the Phoenix and Ms. Schmidt. And if Your Honor recalls, at the time there was default. There's a lot of litigation over the Phoenix's default, opening default. That Mr. Crimer has time on in his bills, but his client was not involved in. She was not a party to the default. She was not in those motions. They were not against her, but he's seeking time for his attending the hearing and preparing for and reviewing, and a lot of time advising his clients on those motions that had absolutely nothing to do with her and did not impact her client.
But except that to Mr. Crimer's point, if he was a plaintiff, that would probably be a more compelling argument. But when you're a defendant, you don't really have any choice but to make sure that nothing that's happening in the case is going to prejudice your client's position. And so sometimes it may be that time spent on collateral issues can be excessive, but the fact that it had to be addressed in order to protect your client's interests when your client didn't choose to inject themselves here, it's a relative concept, I think. I don't think you can immediately say none of that's recoverable, but maybe it's more time than should be necessary. But that's a relative matter for the court to consider in terms of amount.
Right. And our point would be it's excessive. Is the argument that we would make on that. It's excessive and, not necessary. We make the argument it wasn't necessary. Obviously, the court, makes the findings. But, Your Honor, so this happens and we're at this point, we're at about April 2023. And as the court knows, and as, Mr. Crimer alluded to, there was a lot of argument and motions practice about whether this matter settled. We believed and maintained the position throughout the case until the court ruled otherwise, that in April in 2023, Mr. Crimer and I agreed to a mutual dismissal without prejudice of our client's claims against Ms. Schmidt and her counterclaims. I sent in May, and this is all in the record, it's all appended to the motion to enforce the agreement. There was the email in April and May, early May, about May 6, 2023. I sent a proposed stipulation of dismissal. Mr. Crimer did not respond to that. Then in June, he sends me an email that I haven't sent any draft documents. I'm not doing anything about the dismissal. And he had to draft the agreement, which he has time for. But that was inaccurate because the emails show I had already sent him proposed stipulation. The disagreement and what the court ruled on is that we did not have a meeting of the minds as to the dismissal versus release. Mr. Crimer wanted to draft, a release when the emails and the discussion and the drafts had been a mutual dismissal. A dismissal and a release are obviously very different things. A dismissal without prejudice, you reserve a right to bring a case back. A release, you're releasing the claims. So our position was that after the Phoenix was no longer in default, Ms. Schmidt's position changed on the agreement. But we were acting at that time in accordance with the agreement we believed we made. We were trying to dismiss her in April and May of 2023. From that point forward, every single fee that was incurred was there fighting our dismissal of Ms. Schmidt. I mean, when you really look at what was happening in this case, we were saying, we're trying to dismiss. We want to enforce the agreement to dismiss. We want to get her out. We want, our case is over. We had to actually fight to dismiss her. And then what happened is instead of, and the motion to enforce really goes into great detail, because right before Mr. Crimer spent 12 hours on a Sunday drafting a summary judgment based only on admissions, which I believe is excessive, I had sent him an email saying my clients are reviewing, we're trying to work with the document you drafted, we just want to get this done, we're prepared to dismiss, but he's imposed a unilateral deadline and then would not even consider. We sent him the red line back, prepared to sign, and the position was no, we're not going to do it anymore. We're going to go forward with our summary judgment based on the deemed admissions. Admissions we had not responded to, as we argued, because we believed that we had an agreement. Now, the court ultimately ruled against us on that. But in 9-15-14, I think it's important, again, to look at the time things were happening. At the time we were relying on the agreement, we believed we had one. Our actions were in accordance with that agreement. Court ultimately disagreed with us. But the real point, Your Honor, is that they were fighting us trying to let them out of the case and incurring incredibly high fees to do it. Filing summary judgment motions, fighting the withdrawal of the dismissal, fighting the agreement, every single thing they could do to fight us, to fight the dismissal of Ms. Schmidt, which we understood is what she wanted in the first place. So in terms of that, the reasonableness and the necessity, I think it should be looked when the court is considering whether actions were reasonable or necessary. Some of the actions that were beyond what's required to defend her, they were actively fighting the attempts to dismiss her and incurring fees that they now want us to pay for. I think that is relevant when you're looking at the conduct of the Davises throughout the litigation. Their conduct was always consistent with, we believed we had an agreement, we didn't want to incur any more fees for anybody, so we didn't think we had to answer the discovery. And that leads us to the admissions, Your Honor. Mr. Crimer in every pleading argues that these admissions are that there is no evidence, that we admit there's no evidence. But when you look at the admissions, which are filed into the record, they were filed in on August 2nd, 2023. The requests are, you are aware of no direct evidence. No direct evidence does not equal no evidence. In fact, Your Honor, number 8 to both Mr. and Mrs. Davis, your claims against the defendant are based entirely on circumstantial evidence. So aren't we in fact admitting we have circumstantial evidence? So there's no admission in here that there's no evidence. It's that there's no direct evidence. But there is an admission that there's circumstantial evidence. That should not be construed in a 9-15-14 context. I mean, I understand the court adopted Mr. Crimer's proposed order on the summary judgment motion and found no evidence, but the admissions speak for themselves.
Huh? I mean, just to be clear, sometimes I do adopt proposed orders that are submitted by parties, but I wrote that order. It was an omnibus order on multiple motions that were outstanding. I might have used some of the language that was urged by Mr. Crimer as a prevailing party, but I wrote that order. So I would prefer that you not characterize it as my having adopted his order, because I did not.
I apologize on how I characterize it. That was based on the time evidence that he drafted the proposed order. So I apologize if I misconstrued. But, but the point is, the admissions are no, as I said, no direct evidence. We do admit there's circumstantial. And then the other admissions in here are opinion, or the things like, it is possible that someone other than the defendant had a master key. Well, Your Honor, we couldn't have denied that. Of course, it's possible someone other than the defendant had the master key. That doesn't mean there's no evidence that she didn't have the key.
So let me save y'all. Hang on, forgive me, Ms. Brown. Let me save y'all some trouble. Okay. Ms. Schmidt was the listing agent on a sale that apparently wrongly alienated a storage unit that shouldn't have been alienated, right? So it's unlikely that if I award fees, I'm going to do it on the basis that the Davises had no reasonable basis to ever sue Ms. Schmidt in the first place. What I am going to be looking at is the nature and extent. And so the reason I'm jumping in and saying that now is the admissions are not going to control the outcome of this case. They controlled the outcome of the summary judgment necessarily, but and their existence, as I said, I think when we started, are informative to the court about the nature and extent of what the parties had, what the parties thought. But to my way of thinking, from an initial perspective, I don't think it's unreasonable to list the sellers and the seller's agent as at the outset. But what I am interested in, and that's why I'm interjecting to focus everybody's discussion, is at some point, perhaps when there was ongoing discussion about settlement, it became pretty obvious, it seems to me, that the Davises understood that they didn't have a case to urge against Ms. Schmidt. Maybe against others, I don't know who, but not against Ms. Schmidt. And so I am not going, so I tell you that simply because I think we can save ourselves some time, because I don't think it was unreasonable to name Ms. Schmidt in the first instance, but at least based on the record I've seen, it seems like it became pretty clear fairly quickly that Ms. Schmidt shouldn't be in the case anymore, and yet she still was. And so that's, I think, where I am focusing my assessment.
Your Honor, I understand. And I bring these issues up because Mr. Crimer's motion, as he's filed it, and the basis he's seeking, 915-14 A and B, are the admissions. His motion, he's requesting that the court rely on the admissions in granting the fees. That's the whole basis that he submitted to the court in his motion, is that the admissions entitle his client under A and also support a finding under B. And when you read his brief, that is what he points to, the admissions as his basis. And it's his burden to prove a basis for a 915-14 A or B. So our position is these admissions that he's relying on for his motion do not provide a basis. They do not support his claim that this was frivolous litigation from the outset under A, or, that a court couldn't reasonably believe it. And he goes on, and the last point I was going to make about the admissions is he acknowledged in his presentation that he puts in an admission that is essentially the element of the statute. Well, Your Honor, that is a legal conclusion, and it is not deemed admitted because without an accompanying fact. And I have a citation for that, Your Honor, and if I can find the right piece of paper. But, his argument that, we admitted our claims are substantially frivolous does not carry the day that she is entitled to fees. It is an opinion and a legal, or at best, it's a legal conclusion. At best, it's an opinion, but it is not deemed admitted because it's not coupled by a fact. And I have too many pieces of paper in front of me from making notes in preparation, but I will get that citation for that, that proposition. So, Your Honor, that's why I wanted to point to the admissions, because he does argue them as the basis. It's very important, if he's going to use them as the basis for his motion, that they be looked at as to what's being admitted and what's been said. There's no admission that there is no evidence at all to support the claims. But to get to the point Your Honor got to, and I was bringing it up earlier, at the time of the default at Mr. Crimer, and it's in his time records, we were having settlement discussions. It's all in the record, all of the emails back and forth. Mr. Crimer had sent over some additional documents that it's sort of informal discovery, if you will, before the formal discovery response that we, looked at, and our clients made some decisions based on the procedural posture of the default at the time, and also based on some of the documents, to enter into a stipulation of dismissal because Ms. Schmidt had these counterclaims. Mr. Crimer says they're compulsory. I would say they're permissive. I don't believe that slander based on filing of a lawsuit or interference with a contract, I don't think either were even permitted or based in any law or fact. In fact, they're privileged matters. The only allegation against my clients is that they sued Ms. Schmidt. Well, that is privilege. That's not slander per se. That's not libel. So those counterclaims had no merit anyway when they were filed and pursued. But we tried to do the dismissal. We tendered a dismissal. they wouldn't sign it unless it had a release. So
Right,
there
because, but because it was a violent, it would have, what you were offering, and I don't recall, other than an acknowledgement of it being a disagreement between the parties, but at the end of the day, substantively, what you were offering, what the Davises were offering to Ms. Schmidt was a non-final, non-adjudication on the merits, a voluntary dismissal that would, one, allow her to be brought back into the case, potentially, and two, leave open the impression that she had settled the case. And what she got instead was a complete adjudication on the merits, indicating that she had no liability whatsoever. Those are very different outcomes.
I understand, but in terms of looking at what was happening in the case, and when you look at the motion to enforce fees, the initial offer was the dismissal, but Mr. Crimer, we continued to negotiate, and we were giving her the release language she wanted. We sent over a red line giving her the release language. It's in the record. It's attached to our motion to enforce fees. But Mr. Crimer said, no, I'm not going to look at that because I've already filed a summary judgment motion. It would have been the release language. So the Davises were working throughout that time, believing they had settled and were then in good faith negotiating the final document because there were, so it wasn't a scenario where they were continuing to hold claims over her. They weren't prosecuting any claims against her at the time. They weren't doing.
Well, let me ask you this, though. I mean, I understand there's some procedural niceties that have to be asserted when you dismiss less than all the parties. But couldn't you have just filed a motion to dismiss? Like, even if you couldn't have worked it out, couldn't the Davises have said, hey, judge, we're trying to dismiss Ms. Schmidt. She won't let us. We think we're justified. Here's our motion to dismiss.
They could have,
and then the court would have dealt with it.
They would have had to defend her counterclaims. Her counterclaims are still there. She was suing them for $150,000 for alleged slander
but we wouldn't be having, my point is, as a cutoff of the attorney's fees issue, right? If part of your argument, as I understand it, is we were trying to dismiss Ms. Schmidt, they wouldn't let us. And I was simply saying, well, couldn't you have just said, hey, we understand there are counterclaims out there, because that's what the law says. It's not that one is dispositive of the other. I mean, I have to educate people about this all the time that voluntarily dismiss their claims and don't understand why the whole case doesn't go away. And it's because, as you correctly note, Ms. Brown, those counterclaims still exist, but that doesn't mean you couldn't have thrown up the white flag and said, fine, we'll deal with the counterclaims. We think they lack merit, but we're dismissing Ms. Schmidt.
We could, but Your Honor, we also never conceded that she didn't have any responsibility whatsoever. They never gave us a document that said she absolutely had nothing to do with this. We were negotiating a settlement. We were not taking any action against her at that point, we were trying to finalize documents. So while maybe we could have just dismissed, but we would have still been defending her claims, which she didn't even dismiss after she got her summary judgment until the eve of a jury trial. She left those counterclaims and was prepared. I mean, Mr. Crimer did not dismiss those until after this matter was placed on the jury trial calendar and after multiple requests. And ultimately, the Peachtree, the Phoenix was still in. There was the only claims remaining at that point. We had claims against the Phoenix. Once the appeal came down and the stay was lifted, my clients decided they just wanted to be done, concluded, offered just to dismiss everything. We could not, again, dismiss. There was no agreement by Ms. Schmidt and Mr. Crimer to dismiss at that point. So we did voluntarily dismiss the Phoenix, and they continued to pursue, the counterclaim. So at that point, and in fact, even when they dismissed it, Mr. Crimer testified to about 5 or 6 hours of research to see if the court retained jurisdiction on a 915-14. The statute is clear the court retains jurisdiction on the 915-14. So a lot of the work after Your Honor granted summary judgment, Ms. Schmidt didn't just dismiss her claims. She kept it going and he kept incurring fees. And he was also then negotiating with Mr. Wagner about the cross claim. So all of these things were not necessary and reasonable because, the admissions were deemed or because the settlement agreement wasn't enforced. It really does go to necessity and reasonableness of time. The amounts of time, we don't dispute the reasonableness of the a fee. It was originally charged at $350. At the time Mr. Crimer decided to file the summary judgment, it was increased to $395 on that statement. It went $395 forward. Prior to that, the billing had been at $350. So at that point, when they doubled down and, in our view, were, litigating against, they wanted the adjudication. So that was their right, not saying they don't have the right, but in terms of looking at the necessity, I think it should be noted that it wasn't the Davises driving her to incur all of these fees. It wasn't the Davises who were driving her attorney to fight. We wanted to enforce the agreement to dismiss the case. We had sent back a release that gave the language she wanted, but yet the case still went on because at that point they wanted to take it to the adjudication. And I understand the difference, but the release would have been the same thing as an adjudication on the merits. It would have been a release from bringing her back in. But even then, she maintained her counterclaims and continued to litigate the case. So, to say that every single fee that she incurred was the result of my clients having no claim is disingenuous. That is not the case. And every single fee, and the court on 915-14 has to look at the nature of the fees and apportioning them and looking at, there's no lump sum 915-14. You don't, just because you win a 915-14, get all of your fees. The court determines reasonableness and necessity, but also the case law is that you don't get a lump sum award. His client doesn't get all of her fees just because she had to defend the case. And, and looking at crossing, and I'm happy to just make argument on the issues we would cross in, the interest of time, and some of them I've made argument already. There was a lot of time and money spent to exponentially increase the cost of this litigation after the Davises were trying to enforce the settlement agreement. At the time of we believed there was a settlement, there were only $10,000 in fees. Today it's up to $45,000. So $35,000 in additional fees were incurred. And at every turn, it was fighting the Davises' attempt to enforce the agreement. And in terms of the omnibus motion, we did not ignore the summary judgment. We did not ignore the other motions. We filed a motion to enforce the settlement agreement. We asked for an extension of time to respond to the summary judgment after the court ruled on whether there was an enforceable agreement to try to avoid additional costs and fees. That was denied, but there was no, we had asked for a consensual extension on the summary judgment response time, and that was denied. So there was no action by the Davises to just force Ms. Schmidt to spend money and fighting her at every cost so that she had to incur this significant and substantial fee that she's now seeking. The Davises were in fact doing the opposite. They were trying to resolve this to a conclusion as to her, but she still had $150,000 claims against them, and she was also seeking punitive damages against them. And there was no indication that she was willing to dismiss her claims once once Mr. Crimer drew the line in the sand and said, you give me the release by the 15th, or I'm filing summary judgment. Notably, and it's in the record, I emailed him back that he sent me the wrong copy of the release for my clients to get back to. And I sent that to him on Monday, the 17th, following his Friday, the 15th deadline. I sent back to him like, my clients are prepared to sign the red line, but that's not what you sent me for execution. And, here it is again, here's the red line. And instead he said, no agreement. We're not discussing anymore. We're proceeding with the motion that he had, his time entries indicate he spent 12.1 hours drafting the Sunday, the day before. It's a 7-page motion, Your Honor, based on deemed admissions and an affidavit that's a copy from the cross claim. So I think 12.1 hours is excessive time for the motion that it was. But, I don't think it's reasonable that particular motion would have taken any lawyer 12.1 hours to file. But before it had even been filed, we had tendered back the release. And tried to conclude the case there, but it was rejected. So I do think all of that is relevant in determining the reasonableness and necessity of the fees that Ms. Schmidt incurred, because from then it was not only fighting our filing the summary judgment, fighting the motion to enforce, moving to compel discovery and sanctions, even though the admission summary judgment was already pending. There was motions and sanctions motions about interrogatories. He continued to incur time with Mr. Wagner and the cross claim. Nobody was, pursuing that at this point. I mean, at this point, the Davis's position was, we want to dismiss, we're trying to dismiss. And that is the point of the argument, is that it's, when you're looking at the reasonableness and the necessity of the charges from that point forward, and whether that, they had to be incurred, they didn't have to be incurred, if just to proceed with the summary judgment, all of these other, efforts did not have to be incurred. We could have, we had asked to keep litigation costs down, for your honor to rule on whether there was an agreement before we handled the summary judgment. They didn't agree to that, and that's their right. It's their right to proceed with defending the case, but when they're going to come back and then seek sanctions and ask the Davises to pay those fees, then those fees should have some reason and necessity, and not simply be growing the fees and mounting and getting very aggressive with fees to turn around and file a fee motion down the road, which is what it appeared the strategy became, because it was at every turn, there was an effort to avoid a dismissal of the case. And again, to the point, they had every right to go for a dispositive motion, but they did not have to litigate or incur or go to the levels that they fought the dismissal. And I think the court should consider that when looking, at the fees, particularly given it went from a $10,000 in fees at the time of, the agreements up to now $45,000. $35,000 is not a reasonable and necessary fee when the parties were trying to dismiss in the first place. And there was no willingness to give up on that counterclaim. We, in fact, were trying to get it off the calendar before, but, I was told by Mr. Crimer that they weren't going to dismiss it until the attorney's fees motion was dealt with. I mean, in fact, that was the first communication. No mutual dismissal because our fee motion is pending. I pointed out, as is in the statute, the court retains jurisdiction on 9/15/14, pending the disposition and dismissal. I know I saw emails from Mr. Wagner where he sent a stipulation of dismissal, and we agreed to language that acknowledged that the court would have jurisdiction. In fact, no one ever argued the court didn't have jurisdiction on the motion. So there was no need to incur 3 to 5 hours of research and drafting to preserve jurisdiction that nobody was arguing was an issue. So, Your Honor, I think if you review the fees, I mean, from the outset of the case through the April of 2023, we really don't take issue with the fees that, he drafted a cross claim and a counterclaim. They were talking with notably with the individuals we couldn't get served. They were in communication with, fine that, they don't have to tell us how to serve co-defendants, but the time entries indicate that, they were spending a lot of time communicating. They were spending a lot of time looking at the default motion issue and strategy. And there's, hours of entry on strategy relating to what's happening with the cross claim and what's happening with the default, all things that did not impact Ms. Schmidt directly. But where the fees really start to become concerning is in May of 2023, after the May 2023 bill, and it's after the discussions about the settlement. And that is when we get the 12.1 hours for the summary judgment motion. And that's on July 16th, which was a Sunday. That's where we start to get, another 4 hours the next few days relating to the summary judgment motion. And we get, following that, there's fees in August of 2023, where, Mr. Crimer is negotiating, that's fighting the dismissal. These were, starting the motions practice of and moving to compel the discovery. If Your Honor recalls, we had a status conference. At that point, there was some discussion. We had filed our motion to withdraw the admissions. There was a status conference about the interrogatories and document requests, which were extended. We understood from that status conference that the discovery would be responded to later, but then Mr. Crimer filed a motion for sanctions, for fees on the interrogatories and document requests at the same time that the summary judgment was pending. The court entered the order on the motions at the end of September of 2023. And at that point, the motions practice continues and the strategy about her counterclaims and cross claims. At that point, Your Honor, she is out. My client's claims against her are disposed of in September of 2023. From that point, Ms. Schmidt is choosing to keep the counterclaims and cross claims going. She is choosing to continue to incur those fees. And, there are about 5 hours then for the brief on the motion for attorney's fees on one day, over 8 hours of time to draft the brief on this motion, which is just about 5 pages long, and again, relies entirely on the admissions. So I do believe that the court should, and we would urge the court to look very carefully at the time entries that are being, versus what the work that was being produced, because while the rate may be reasonable, the time spent is not reasonable or necessary for the work that was being done, especially with an attorney of more than 40 years of experience. When you're taking admissions and copying them into a document, it doesn't take 8 hours to draft a motion. And I think that, and we also, once the Davis's claims are adjudicated, it is Ms. Schmidt voluntarily continuing to incur fees and move forward with her case. Because at that point, in October, there's multiple hours of Mr. Crimer negotiating with Mr. Wagner about the cross claims. And, the Davises have nothing to do with that. They were out, their claims had been adjudicated. The Davises had claims against Mr. Wagner's client, but those did not involve Ms. Schmidt at all. But there's no discussion with us about the counterclaims. It's conversations with Mr. Wagner about the cross claims and counterclaims. But they remain pending, and this case ultimately gets put on the court's trial calendar. So I think in reviewing the bills, it's very important to look at this is not a case where a lump sum of fee should be considered because every single item was necessary to the defense. Every single item. I think that and even if there's a determination that every single item was necessary, the time charged and the amounts charged for many of those items is excessive. And we would urge the court to look at in reviewing these fee statements that are in evidence, and rather than cross, I have highlighted the issues that I would have asked Mr. Crimer about, which would have essentially been, is this your time entry 12.1 for summary judgment? So in the interest of time, I just stated our objections in argument form, but those are the issues that we would ask the court to look at. At no time was this case ever one where the Davises were just trying to sue everybody and just shotgun pleading or trying to harass Ms. Schmidt or trying to damage her reputation. They were trying to recover their property, and they were doing their best. They had been out of the country. They came home and all of their property had been removed because someone told Ms. Schmidt and her clients that the storage unit belonged to them. This has never been an attack, but Ms. Schmidt took it as a personal attack, as evidenced by her counterclaims, which, again, slander per se, you can't have slander and libel per se based on the filing of a lawsuit. That's privileged. It's statutory. I believe it's 51.5. I did print that out. I can give Your Honor it's OCGA 5157 and 5158 provide absolute privilege of allegations in pleadings and demand letters from attorneys. All that happened here is that the Davises ask what happened to our stuff. They go to the association. The association says, it was sold. Bobby Schmidt sold it for this. I mean, we get the identity of the parties and who was involved. And then it becomes the Davises are going above and beyond to try to find out where is their stuff, because all they wanted was their stuff back. They didn't want to litigate. They didn't want to have to incur all of these fees. They didn't want, they weren't on some witch hunt against everybody involved or accusing people of reprehensible behavior or as characterized in the opening. They were trying to get their stuff back, and they were doing their best to as efficiently as possible. And then, they did their best to manage this litigation. They did not fail to prosecute anybody. They didn't ignore defendants. Just because they couldn't get someone served doesn't mean that they weren't prosecuting their case. They believed in good faith that they had an agreement. It was ultimately ruled that they didn't, but all of their actions up until that ruling were consistent with their belief that they had an agreement. So, everything that was done here was done based on a good faith, justiciable issue of fact. There's no substantially frivolous claims. There's nothing substantially vexatious. They didn't unnecessarily prolong these proceedings. They didn't do any of the sanctionable conduct that 91514 is designed to deter. They simply tried to bring a claim to recover their property. And, given they ultimately decided prior to going to a jury trial, to dismiss, because at this point, Ms. Schmidt's claims were still pending against them. They had lost on the summary judgment. The admissions had been deemed. Things had not been going their way. But at no time did they act in bad faith. At no time did they unnecessarily expand. At no time did they force Ms. Schmidt to incur $45,000 in fees. And we would ask the court to not grant her any fees, because the basis for the motion as filed and as brought was solely on the admissions. The admissions do not prove 91514A or B, so the motion should be denied. But if the court does consider an award of fees, we would ask that no fees be granted, 0 fees be determined as reasonable or necessary in this case.
Thank you, Ms. Brown. So I think, just to be clear, I think you indicated that you've made the arguments you wanted to make about the time issues.
Yes.
And that you don't necessarily think that you need to cross-examine Mr. Crimer. Is that correct?
I don't think so. I don't need to take the time, everybody's time, to ask him the time entries that I've pointed out.
Okay. Thank you, Ms. Brown. Mr. Crimer, it's your motion, so you get the last word.
You're on mute, Mr. Crimer.
Yep. Yeah, Mr. Crimer, you're muted. Wouldn't be a Zoom hearing if I didn't have to say that at least one time.
All right, am I back in live here?
Yes, sir.
Okay, I apologize. Let's see where we were. That was a lot to unpack. I guess an hour, 15, 20 minutes of argument. So let me see if I can boil that down to a couple of salient points. Number one, we did not pursue a counterclaim ever at any time, spend a nickel other than just filing it quickly. You're an experienced litigator. You file counterclaims, compulsory or not. You want to be sure you get them. You don't want to overlook it. Had to do that. But we didn't spend any meaningful time on that at all, ever. Number two, Your Honor had a great question. Why didn't they just dismiss it at any time? They didn't need to wait for me. They could have just dismissed it at any time without permission of the court. You said you have to file a motion to dismiss. Maybe I'm getting a little rusty here. I didn't realize you needed permission to dismiss in state court.
It's not permission, but there are some, I think is it 9/11/21? I'm probably calling the wrong one, but I think there are some procedures now where if you're dismissing less than all of the parties, you need the imprimatur of the court, but it's still something that could have been unilaterally undertaken by one party that's seeking to dismiss another party.
And certainly no one would have opposed it. Really more to the point in light of that, you're right. You got me there. You are right when you have multiple parties. Why did they pursue an appeal? I mean, all signs were that they wanted to litigate this and fight this to the bitter end, which is really so important and essential to the background of my filing the summary judgment motion. We tried, the court was well aware in the court's order that the court drafted, as you pointed out. We made endless efforts to get it resolved, and it just wouldn't happen. And one thing I will point out, I guess we've gotten a little bit of crosstalk between lawyers, but I think it's in the record as well. They wanted us to give testimony against Steve Marshall. That was one of the conditions that they required as dismissal of this
Refresh
case.
my recollection. Steve Marshall was the seller.
No, ma'am, he was he lived there. He had a power of attorney for the seller, Joe Doc. Joe Doc lived in Australia, in Austria. And so he gave Steve Marshall a power of attorney to attend the closing.
Okay. I wasn't looking necessarily for substance as much as I was looking to make sure I understood which one of the players he was. So he was the power of attorney who was also named as someone because he was authorized to act allegedly on behalf of the seller. Is that right?
Yes. It sure is. And just so you know, Cameron Marshall's his son. So everybody got sued that had anything remotely to do with this. So trying to remember what else I really wanted to say. I don't think we base this motion solely on the admissions. I think that's important. I think largely it's based on the summary judgment order that you entered and some of the rulings that you've already made in this case, and I think that are maybe the law of the case or somehow binding. While I was listening to Ms. Brown arguing, I was looking a little bit more at 9:14:15 in the language. And I gather from the court's remarks, we're looking more at subsection B rather than subsection A. Subsection B says that the court may award discretionary if it lacks substantial justification. The statute goes on, I'm sure the court's very familiar, that substantial justification is defined to mean substantially frivolous, substantially groundless, or substantially vexatious. I start with vexatious. I doubt that Ms. Brown did it to be vexatious. I don't know that, but I don't know what their thinking was with her clients. It was absolutely substantially groundless and maybe frivolous, but groundless probably, Judge, would be the key argument. And then as far as groundless is concerned, I think Ms. Brown made a statement that is simply not correct, that there was no other evidence to know that it was groundless. There was. Here's first of all, we had the answer. She knew from the minute she got our answer that we certainly disagreed with half of her allegations. And then Ms. Schmidt filed an affidavit, which I, of course, drafted, but it says that all she did was help to get a key, or she requested Steve Marshall to get a key. That's what she says, paragraph 6. Paragraph 7, thereafter, I had no involvement whatsoever with the storage unit 402. I did not at any time obtain or possess a key, did not at any time access, did not allow or instruct anyone else to do so. I believe, Your Honor, those are all the kinds of statements that you look to in your summary judgment order. And she goes on, I did not any time enter 402, I did not any time possess or remove any property, didn't have any knowledge of anybody. I mean, it couldn't be more clear. And for the record, I told Ms. Brown every bit of that when we were talking about settlement. So she knew that from me. She didn't have to wait for an affidavit from Bobby Schmidt. And yes, lawyers say things all the time, but I think Ms. Brown knew and certainly should have known that it was very, very thin evidence. And again, this is awkward and unpleasant for me to be arguing back and forth about a fellow attorney, but there's just no evidence there. And that's why I did try to travel more on the admissions than getting into the weeds with what I said to Ms. Brown and what she said to me. That's kind of awkward. I think Your Honor made a great point when I told her we had to get a settlement done or else I would file summary judgment. And she could have just gone ahead and gotten it done then, but she didn't. Instead, she files a motion to enforce, and she didn't even answer the summary judgment. And I just think that does go to a certain frivolousness of the attitude toward this complaint. It's a very, very serious matter to sue my client, a real estate agent, or anybody for that matter, but especially a real estate agent in that building, and accuse her of potentially committing theft and potentially for felony. That's just not something you lightly do. This is not just a simple negligence case or even a breach of contract. It was pretty doggone serious. And Ms. Brown tried to sort of push away our counterclaims for libel and slander. I think they were extremely well justified if my client was accused of a potential felony. And to repeat quickly, we didn't spend any time on that. As Your Honor knows, Ms. Brown made clear, she appealed it right after your order within 30 days, as you know, and so the case was pretty much stayed for the rest of the time. And then as soon as the remitter came back, all we did was ask for a hearing on our motion for attorney fees. We never did one more single thing after that, after the summary judgment. So I just think a lot of Ms. Brown's comments are not justified. The only other one that's substantive that I think I would like to address is the filing of the summary judgment motion. And so that's going to be in my third affidavit on July 31 of 23. And I'll just go through it. Review all the pleadings and requests for admissions an hour. And that's not an excessive amount of time to go through all the pleadings and get up to speed. Draft the motion for summary judgment. Well, that's pretty simple. 20 minutes, I think I have for that. Statement of material facts. Judge, you've done this. That takes 2.5 hours. That was not easy to do, to go through all of that. And draft up Ms. Schmidt's affidavit that I just read to you. All that took half an hour to do her affidavit, together with the statement of facts, which was based on that affidavit. Then my own affidavit, I put down for my own affidavit 10 minutes for my own affidavit, which I'm sure it took me longer than that, but I only put 10 minutes, 12 minutes. Research cases. Oh, yeah, Your Honor, this is why it took a little while. She had 5 counts in the complaint. So I had to look to the law about conversion. Spent 40 minutes to do that. That's hardly excessive. Trespass, spent 30 minutes to do that. Attorney fees, I spent another 40 minutes on that, and punitive damages. Those were all of their claims in their case, and I had to look at the law and recite all that in the brief. Then to draft a brief, I did spend 4 hours, which, again, we're all lawyers in this conversation. I did an original draft and a redraft. You just don't sit down and write a stream of consciousness. It takes a while to do it. 4 hours for a 5-count complaint, that's not excessive. Then I talked to Ms. Schmidt about it for 25 minutes, and then I sent a draft for her to review for 10 minutes. I don't know why that took me 10 minutes, but maybe I had to put it all together, and it took several minutes to do it. So all of that added up to 12 hours. And Ms. Brown probably said 15 times that that was excessive. And I vigorously deny that. It was not only not excessive, I think it was probably understated, because I just don't overbill people. For the same reason I gave Ms. Schmidt a lower hourly rate, I didn't bill her for every minute. If she were to testify, I know she'd say, I talk to her all the time and don't bill it. I just don't do that. Try to treat clients like I'd like to be treated, and I don't charge them for every 2-minute phone call. So if anything, my time is underestimated, and I take some offense at the idea that it was unnecessary. I've been a lawyer a long time, and I don't waste time and don't have any need to just pad my bills. That's just not right. If you'll give me a minute, Judge, I'll look through my other notes, and then I'll be finished. I think, Your Honor, are you still with me?
Yes, sir.
Okay, I'm sorry. You've gone off screen, so I'm so used to calls being dropped off.
Nope, I'm still here.
Always reassure. All right, I'm almost at the end. Thank you. Well, it just, I don't think my fees were excessive. I think that's, oh, I know what I was getting to. You made a comment earlier that you were looking to this, and you made the comment that you thought that the naming of my client was not unreasonable. And I would respectfully disagree with that. You have to have some factual basis to do that. The mere fact that she had some relationship to that sale from Joe Doc and was in some way involved in it, why didn't she sue the other real estate agent? There was a selling agent involved. Forgotten her name now, but there was another real estate agent involved. She didn't sue them. The plaintiffs didn't sue that agent. And there were other potential defendants that could have been sued. And respectfully, I just think they sued my client because she was an easy target. And I think there's some bad faith in the idea that they wanted to release. There was never just, oh yeah, we'll go ahead and release her. I know we don't have any evidence. Ms. Brown and I talked about that many times. And I said, there's no evidence. You're never going to find any because there isn't any. She had no reason to do that. So she knew that very early on in the case, certainly from the time they got my answer. So with that said, Your Honor, I do believe that all of these fees were reasonable and necessary to be a good lawyer covering all your bases. And we did dismiss the case. And that took a little while. Back to the jurisdiction, 915-14 does say you can file it up to 45 days after the case is dismissed. I've read that in 1 minute. I get that. But it was a little unclear what happens if you have a motion that was already pending prior to the dismissal. And that took me a while to find some case law. And in fact, I never found a clear-cut case, but I just think that was absolutely appropriate for me to research that and not have Ms. Brown say, oh yeah, the case is dismissed and your attorney fee claim is gone. I had to be very sure about that before we dismissed the claim. And then once I was reasonably comfortable about it, that you did retain jurisdiction, we dismissed it without further ado. So anyway, I think you've heard enough. You've been more than patient. If you have any questions, I'm happy to answer it, but I think we're entitled to all these fees and expenses and respectfully request the court to enter an order against both Ms. Brown and her clients. Quickly comment on that. I don't know what she told her clients, what they knew or didn't know. All of that's privileged, obviously, and I can't find that out. But there's a good case, Burkhall versus Rosenthal.
Your Honor, there's no written notice that this motion is against me. This is the first time his request that fees be awarded against me was, his motion does not ask for fees against me. I was not put on notice that I was defending a fee claim against Mr.
Excuse me, please. Can I finish, please? I didn't interrupt you. Could I please finish?
Ooh, I think that's probably fair. I'll let Mr. Crimer finish, and then Ms. Brown, I'll let you address that issue. So y'all know, I was also looking at the motion to understand whether or not it was sought against Ms. Brown. And I think it's, at least as I read it, and I'll hear from both sides on that particular very limited issue, but as I read it, it's written so broadly as to simply ask for 915-14 fees, ask for an award of fees based on either A or B, and that the claims lacked substantial justification, et cetera, and not necessarily that it is directly saying I am seeking attorney's fees from the plaintiffs or from the attorney. I understood it to simply say I'm entitled to fees. That's how I understood it. And of course, 915-14 allows the court to award fees if the court determines that fees are appropriate against the attorney or the party or both. So, Mr. Crimer, I'm going to let you finish that thought, and then I'll let Ms. Brown address that issue.
Thank you, Your Honor. Looking at my brief right now, it says request the court to schedule a hearing and to enter an appropriate award in favor of defendant. I deliberately wrote it that way because I didn't really know and what their response was going to be. And I want to comment on that too. Counsel never responded to the motion. I really didn't know what she planned to argue today, and I take some grievance with that. It's just not in my opinion, with all due respect, it's not a professional way to practice law, to just come in and sandbag me with what the arguments are. And it took a lot more time with the court than it should have to do all that. And that's why I said an appropriate award. I didn't really know what their defense might be. It could be that she had different information. I have no idea. And so really didn't know what her position would be even up until today. It was all news to me. So again, the statute very explicitly says the court can award fees against the attorney or the client as the court determines which is appropriate. And so I was waiting for the hearing today just to see who said what to whom. Maybe Ms. Brown didn't understand things. Maybe the clients told her things. I don't know. And that's privileged. I'll never know that. So I submit that it would be appropriate to enter an award against both of them, but I'll leave that to the court's discretion. So that's all I have. Thank you, Judge.
Thank you, Mr. Crimer. Ms. Brown?
Your Honor, in 915-14, being it's a sanction, I believe it is practice to put an attorney on notice if you're seeking fees from the attorney as well as the clients. A general statement that we're entitled to fees does not provide that notice that it's coming for the attorney. I had no opportunity to tender it for defense should I've chosen to. I had no, and if Mr. Kremer indicated he read Ms. Mast's article on 9/15/14, and that in fact is one of the recommendations. If an attorney is named, if fees are sought from the attorney, to tender it to your carrier. I was not given the opportunity to prepare evidence defending myself. You know, I came here today defending my clients on a claim for attorney's fees, only for him to say at the end that he's seeking fees against me because of his opinion of, you know, how I handled the case. I think that if he wanted to seek fees against me as counsel, then that should have been stated in the motion. It should have been clear. I understand the statute allows the court to award to a party, the attorney, or both, but I don't believe that the statute does not require that the party be on notice if a fee claim is being made against them. You know, I was not on notice to defend myself. I may have had another attorney come so I could put on evidence in my own defense, rather than, arguing my client's position. So I think for, a last minute fees against the attorney too is inappropriate. I think fees in this case in general are inappropriate, but certainly inappropriate as to me without any notice or opportunity to prepare on that issue.
Okay. So I actually, for the last, I think, 3 years, have taught a CLE on the award of attorney's fees, including the award of attorney's fees under 9/15/14. And so I'm familiar with the procedure. I'm familiar with best practice. But I I don't disagree with you, Ms. Brown, that those are steps you could have taken. I do disagree with you that the motion itself didn't put you on notice. 9/15/14 very clearly says that the court is authorized to award fees against the party or the attorney or both. And Mr. Kreimer's motion, as I read it, is deliberately vague. Well, I say deliberate, that it gives that asserts intent toward him, but it doesn't say who those fees are sought from. And in my experience, I will say that where the allegation is procedural, ongoing, and posturing in a case, that frequently implies the actions or decisions of the attorney. And then there will be an open question as to the nature and extent to which the attorney was merely following the bidding of the client or was undertaking those actions at their own behest based on what they believed was appropriate legal action to take on behalf of their client to litigate an issue. So I don't think that there was, well, one, I think we're all in agreement that even if it might be best practice, I am not aware of any such requirement, nor am I aware of any case law that would indicate that a failure to provide such notice formally and procedurally would be dispositive of the outcome, even to the extent that notice is advisable or necessary. As I said, I believe that the motion doesn't say I want fees from the Davises. It says I want fees under 9/15/14. And under 9/15/14, an award of fees can be attributed to the attorney or the clients or both. So that's the court's position on that issue. But that doesn't answer the larger question, which is whether or not an award of fees is appropriate in this case. I think that there is some amount of attorney's fees that is probably justifiable in this circumstance. However, admittedly, I think I said that at the outset, I have not reviewed Mr. Kreimer's bills in detail. And although I'm not persuaded necessarily, Ms. Brown, that 12 hours is too long when you break it down for the actions that were taken, There are some places where there may be some reduction or offsetting, whether, offsetting in terms of actions taken by Mr. Crimer to further the, postural position of the client or the counterclaims or, other things. And that's something that I'm going to look at. But I do, as I said, I at the outset, I've said two things. I just want to be clear that everybody's clear on what my thought process is, because I'm not going to rule today in terms of enter an order that says that Ms. Schmidt is entitled to attorney's fees in X amount. What I am going to say, number one, I've already said that I'm not going to, under no circumstances is any order that I enter going to say that it was substantially groundless under 915-14A at the outset to name Ms. Schmidt as a party. I understand that Ms. Schmidt disagrees with the court's finding in that regard, but I think that at the outset of this instance where there was factual information alleged in the complaint about Ms. Schmidt's role in obtaining access, right, attempting to assist in obtaining access, that might have been later countermanded by the admissions. But those facts did exist. And so I don't think it was necessarily unreasonable for the Davises to pursue a claim against Ms. Schmidt. So that's number one. Number two, however, is I do think there might be a basis for the court to award some 915-14 fees, particularly where we get into the let's resolve the case, but the case doesn't get resolved. And instead of getting resolved, the scope of it was expanded with some additional, motions and briefing. And I understand Ms. Brown's position is that, she lays that at the feet of Mr. Crimer in the sense that, well, we were trying to resolve it and he's the one that decided to file a summary judgment motion. I don't see it the same way. But that's what I'm going to be focusing on. And so all of that is a long way of saying this. What I expect I will end up doing is awarding some amount of fees under 915-14B, and that it will be an amount significantly less. I don't know exactly because I haven't reviewed the billing and figured out what I think are going to be acceptable time constraints, but that it will be an amount less than the total fees that are sought by Ms. Schmidt. And that's going to be my, it's not a ruling because I'm not entering an order today, but just so that the parties leave the hearing with some understanding of what it's my intention to do. And so what typically will happen is that I will, full disclosure, I'm leaving later today to take my child to a college tour in Colorado. So it's not going to be today, but I intend to later this weekend or early next week make a final decision. And what will happen is the parties will receive an email from Mr. Freehoff advising of what my ruling is going to be, and then asking probably for a proposed order for Mr. Crimer. That I can edit, review, reevaluate, et cetera. And that's probably how the procedure will go from there. And then once I enter a written order, the parties can take whatever steps they believe are reasonable in follow-up to that order. Any questions, Mr. Crimer, regarding the outline of that? Of what I just said and what I plan to do in terms of steps I'm going to take next.
No, Your Honor, not at all. Thank you for your time.
Ms. Brown, I understand you disagree with what the court has said, but in terms of what I have outlined and the next steps, any questions or anything you want to address?
No questions on the next steps, Your Honor.
Okay. Anything else that we need to address before we adjourn for the day, Mr. Crimer?
Not in this case. We can talk about other things, but not in this case.
Thank you. No. Ms. Brown,
right.
Anything else you want to address?
No, I mean, we presented our arguments and the record, so, nothing else to address.
Okay. Thank you all for your time, and I will be in touch with a ruling, like I said, early next week. Thank you.
We are excused, I take it.
Yes, you are all excused.
Thank you, Your Honor.